Ladies and gentlemen, please rise for the singing of the Philippine National Anthem.
Awit ng Pilipinas.
Kayang mag-ibig, telas ng sinakalan, alam ng puso, sa titik mo'y buhay. Lupang hinirang, tuyang ka ng magiting, sa mandulupin, di ka pasisigil, sa nagagang tutok sa simoy at sa langit mong pagaw, ay hinatang tulakaw, isang pagkayang minamahal, ang isang ng matawan mo'y tagumpay na nag-iingin, ang bituin at araw niya kailan ang ay di magtitinig. Luman ang araw ng walhagit pagsinta, buhay langit sa piling mo. Ang inigaya na pagkay mga api, ang mamatay ng dahil sa'yo.
Ladies and gentlemen, you may now take your seats. A beautiful morning and mabuhay, ladies and gentlemen. Welcome to the 10th ASEAN Competition Conference, or the 10th ACC. This is co-organized by the Philippine Competition Commission, the ASEAN Secretariat, and the ASEAN Experts Group on Competition. Shall we give our organizers a well-deserved round of applause for gathering us together for a two-day conference? And we thank you for your presence here today. My name is Isa Litton, and the honor is all mine to be your host. Now, I believe this 10th installment of the ACC returns as a springboard for dynamic discussions, literally happening on this very stage, and we hope even in your tables. Lend us your ears, and yes, your comments and questions via a Slido deck later on. So we will be discussing the most pressing issues and the latest developments regarding this interplay between competition policy and IP rights regulation. With the local value chains integrating more rapidly with regional and global ones, this year's ACC aims to explore emerging best practices so that everyone benefits indeed in dealing with IP concerns in antitrust while fostering innovation. After all, we can only hope to continue to move forward, and hopefully we do that together and align with our values. Is that a yes? Thank you. That's a great start to the morning then. So as ASEAN undoubtedly continues to be one of the fastest growing regions in the world, stakeholders from member states and everywhere across the globe are in this very ballroom today for our event, for our conference. Please give yourselves a round of applause, and we hope you had a wonderful stay so far in Manila. Yes? There is coffee, breakfast is served, and trust me, you will have snacks in between. You're going to be well fed and well caffeinated as we go through today's program. You're going to last until tonight. Keep the giggles coming, ladies and gentlemen. So yes, let us now distill key policy insights essential to the common goal of a more robust, more innovative, and more inclusive ASEAN economic community. With that said, let us now open our program. To start us off, we give you the Philippine Competition Commission Chairperson, Mr. Michael G. Aguinaldo. Good morning, Mr. Aguinaldo.
Good morning, everyone. Wow. It's my great honor to welcome you to the 10th ASEAN Competition Conference, or ACC. This ACC is the culmination of months of planning and preparatory work, and its implementation would not be possible without the cooperation of the distinguished speakers and panelists who will be joining and lending their expert insights regarding the state of competition across multiple industries and sectors throughout the region. We are grateful for the steadfast cooperation of the ASEAN Secretariat throughout the preparations for this event, and we hope the 10th ACC can add another footnote to the ASEAN's cultivating of a truly competitive business environment in the region. Let's give a round of applause for the ASEAN. I am honored to acknowledge the presence of our Chief Justice, the Honorable Alexander G. Hesmundo of the Supreme Court of the Republic of the Philippines, who will be our keynote speaker today. We thank you, sir, for participating in this 10th ACC and look forward to your discussion on trends in cases decided by the Supreme Court specific to intellectual property and competition law. We want to see how the judiciary views the act of balancing seemingly counterintuitive policy objectives and how procedural rules on administrative searches can reflect this. I'm confident that the Honorable Chief's keynote address will provide us with a larger perspective that will remind us of the primary objective of such laws: consumer welfare and the public good. To our moderators and panelists for the next 2 days, the PCC is honored by your participation. We look forward to learning from all of you, experts and specialists in your respective fields, and hope that we can together find solutions to some of the issues we are confronted with today. Truly, many of the problems we face today are unprecedented, both by nature and in scope. That's why our plenary sessions will be tackling emerging issues, such as intellectual property regulation in the pharmaceutical industry specifically, anti-competitive practices through licensing in ASEAN markets, the rise of artificial intelligence, intellectual property in digital platforms, promoting market access in biotechnology, and the relevance of competition to technology transfer, just to name a few, presumably with a litany of subtopics in between. Given these topics, certain key questions need to be addressed in order to identify a way forward. How can ASEAN member states mitigate anti-competitive effects of mergers and acquisitions, specifically in the pharmaceutical industry? How can we augment our licensing processes to ensure better prices for consumers? How worried should we be about AI? How can intellectual property regulators and antitrust enforcers collaborate to protect consumer welfare in the digital age? How can we prevent unsavory conduct in the biotech sector that hurts competition and, by extension, consumers? What concrete steps can we take to ensure smooth technology transfer between jurisdictions? These are just some of the questions posed to us, and while these issues are daunting, I'm confident that our moderators and panelists will find the answers today. No, probably not, but I think they're equipped with the knowledge and experience to tackle them and show us the way to find those answers. It is my hope that following today, we retain the lessons and insights shared in these plenary sessions and find novel and exciting ways to apply them in our respective fields of work. In doing so, it is my hope that these small but significant contributions form part of the nation building we should all yearn to be a part of. It is through this collective nation building that we can create a stronger, more resolute ASEAN region where all can reap the benefits of sound competition policy, solid intellectual property protection, and continuing innovation. To properly address all the foregoing issues means taking into account the root causes of these mounting issues. And the first step to overcoming them involves acknowledging what these root causes may stem from more than one particular industry or sector. With the increasing integration of value chains, both within our region and beyond, it has never been more relevant to explore emerging best practices across our respective fields in order to ensure a comprehensive approach towards problem solving. It is through events such as these that we have the opportunity to shed light on these issues, find common ground, and charter a path forward that will be beneficial to all of us. Once again, I want to thank you for taking time off from your busy schedules to participate in the ACC. I look forward to learning from you all and building stronger relationships with you all. And I'd like to welcome you again to Manila, the Philippines. Thank you, good morning, at mabuhay po kayong lahat.
Thank you very much, PCC Chairperson Aguinaldo. And now, ladies and gentlemen, to deliver his opening remarks for this conference, he is not physically with us, but he did send his opening message. Here is the Deputy Secretary General of the ASEAN Economic Community, His Excellency Satvinder Singh. Please watch this.
His Excellency Michael Aguinaldo, the chairperson of the Philippine Competition Commission, distinguished commissioners from all the ASEAN member states' competition authorities, esteemed speakers, colleagues, ladies and gentlemen, a very good morning to all of you and warm greetings from the ASEAN Secretariat in Jakarta. It's indeed my pleasure to join His Excellency Chairman Michael Aguinaldo in expressing a very warm welcome to the 10th ASEAN Competition Conference. I wish also to take this opportunity to extend my heartfelt gratitude to the Philippines Competition Commission for the exceptional hospitality and all the dedicated efforts in hosting this very special ASEAN Competition Conference, which celebrates a decade of convening the premier forum. As we gather here today, ASEAN is also at a critical junction where the complexities of a rapidly evolving global economic landscape and the accelerating pace of digitalization is embracing both opportunities as well as creating challenges. Hence, the conference theme today, which reads From Innovation to Impact, Synergizing Antitrust and Intellectual Property Regulation for a Stronger ASEAN, it truly captures and becomes a lot more valuable. And all this is contextualized nicely, underscoring the pivotal role competition policy and IP regulations coming together in shaping our vision to harness the new dynamics for our ASEAN economic growth. Ladies and gentlemen, as the year of 2023 draws to a close, it confirms the continuous growth of the ASEAN economy towards being a lot more integrated, a lot more competitive, and definitely a lot more innovative market. ASEAN holds a central position in numerous free trade agreements, which opens doors to vast markets, adding a lot more and momentum to our growth and prosperity in the coming future. The main one, as you all know, is the RCEP agreement, the largest FTA in the world that connects the 10 ASEAN countries to our large trade partners of Japan, China, South Korea, Australia, and New Zealand. The ASEAN economy has benefited from that all. It has reached a nominal GDP of almost US 3.6 trillion in 2022, solidifying our position today as the fifth largest economic bloc globally, with a population now exceeding 670 million people, half of them under the age of 30. Definitely the regional market has been able to facilitate trade flows today amounting to about USD 3.8 trillion in goods and another US dollars 930 billion in services. Despite the impact of the pandemic, foreign direct investment in 2022 has also reached historical highs of 224.2 billion, surpassing the pre-pandemic levels and making ASEAN the second largest recipient of FDI in the world after the United States. ASEAN innovation capacity, whereby IP is one of the strategic contributors, it has continuously been serving our region's advancement. All of our ASEAN economies today, we continue to be making steady progress as illustrated in the WIPO Global Innovation Index. In short, it's called the GII Index. Some of the ASEAN member states have firmly hold the top GII performance. In fact, over the past 2 decades, ASEAN investment in research and development have increased fivefold. It's reaching today USD 50 billion in value. the value of high-tech exports has also doubled in 2022, amounting to over more than $500 billion to the ASEAN economies. Venture capital investments have also surged to the amount of $110 billion US, making a notable 60% increase from the pre-pandemic. The numbers of unicorns, one of the greatest signs of innovation, have also increased in the ASEAN. It was only 2 of unicorns in 2014. There are now over 50 unicorns in ASEAN. Meanwhile, there is a substantial growth in IP application with an increased rate of 70, 80%, and 100% in patent, industrial design, and trademark registration, respectively, all increasing from the year of 2012 to 2022. So you see, ladies and gentlemen, we definitely see antitrust and intellectual property regulations mutually supportive. Antitrust, as you know, safeguards fair competition on one hand, establishing a level playing field for all businesses, thereby enabling market liberalization and encouraging innovation. On the other hand, IP regulations serve as what I call a foundation for creativity and innovation, incentivizing R&D and, of course, technology transfer. ASEAN's commitment to establishing a robust economic community has definitely involved significant advancements in both fortifying healthy competition and at the same time propelling regional IP institutions with a critical focus on synergizing these two pivotal elements. Successful progress has been recorded. All of the ASEAN member states have enacted competition laws, and they have also strengthened the capabilities and the effectiveness of their competition authorities. Harmonization and convergence of competition policies and regulations across the ASEAN member states have been promoted. At the same time, we've seen regional cooperative mechanisms established, and a fair competition culture in the region has been advocated. In the realm of intellectual property, concerted efforts have been also bearing fruits for us. This include, of course, an improved IP legal framework. What we've also seen is reinforced IP offices around the region. We have also seen modernized intellectual property infrastructure, which are collectively elevating the regional intellectual property service quality and helping the region to achieve towards best practices at the global level. Now, despite all of these good, significant progresses that I've just shared, we still feel that considerable challenges still lie ahead for us, and notably, especially in the area of achieving a harmonious balance between antitrust, at the same time balancing it with IP regulations for the region. As we strive towards a kind of a future-ready single ASEAN economy and vision for the 2045, and we aim for an accelerated digitalization and a greater advancement of transformative technologies, and hope to achieve growing dynamism of our economic landscape, I think all of this is coming together to intensify this issue between the harmonious balance between antitrust and the IP regulations. Specifically, technological rapid evolution in the digital space, it kind of blurs the lines between innovation and fair competition. It's definitely making it harder to measure market dominance obtained through IP rights or data-driven businesses, as well as defining antitrust and IP regulation boundaries. While disruptive innovation benefits the ASEAN MSMEs, at the same time, unfair exploitation of IP laws and the overly strict protections might actually impede their competitiveness, leading to a potential monopolization by the larger entities that again might extend their patent lifespans, and as a result, it may harm consumer welfare. Noteworthily, I must say that the ASEAN rapid economic development and the highly integrated markets, they tend to outpace the regulatory evolution in regulating competition and IP. What we have seen is cross-border transactions may clash with inconsistent legal frameworks and its enforcement mechanisms in the region, especially when dealing with IP-related goods and services in the digital age, where we have seen data-intensive transactions and online platforms clearly suffering from some of these issues. It is leaving gaps for our established traditional antitrust and IP regulations, struggling to adapt and to fulfill with aims to support synergy between these two crucial elements for the longer term. So you see, ladies and gentlemen, it's evident that both antitrust and IP protection, they do share the trio common goals: the driving of economic growth, the fostering of fair competition, and the encouragement of innovation. But at the same time, the challenge emerges when either system, whether it's IP or antitrust, is given undue balance. I think that's where the challenge is. So therefore, achieving the synergy, it definitely demands nimble, it demands comprehensive and adaptable solutions at both the national and regional tiers in admitting and stopping this challenging environment that we live in. As such, we really need to be looking at deepening our vivid discussions in forums like this. And I also feel that it's time that we could highlight some critical questions as food of thought for all of us to consider as we are discussing some of these modern day issues and challenges. First, I believe the advent of digital technology also has profoundly altered the landscape of competition and all of the necessary measures for protecting intellectual property. Now, the potential misuse of big technology platforms have also worsened the challenges due to their substantial network effect. And we've seen some of the irresponsible utilization of AI could also significantly hamper sound competition. Now, how can national and regional legal frameworks adapt to effectively address some of these challenges to ensure that fair competition and a robust protection of intellectual property rights can exist side by side? It's an important question. Now, the second important question, I believe, is how can ASEAN establish a much more stronger mechanism to strengthen the intellectual property protection framework, while at the same time fostering intellectual property monetization, particularly through the execution of the ASEAN framework for advancing digital startup growth. The question is, how can ASEAN also help upgrade provisions within the antitrust laws that will help stimulate innovation, that will help encourage the valuation of intangible assets among the MSMEs, and also help mitigate some of the unnecessary barriers to IP subsidies? Third question, I think, is also important to consider is how can ASEAN create a regional platform for policy dialogues to be sharing perspectives and the best practices in regulating competition, especially during this period of constant and extreme changes that are being brought about through the digital era, while at the same time ensuring that IP innovation continues to be the driver of growth. I think these are all critical, not easy, but they are all critical questions, challenging issues that we need to tackle. And they're all happening simultaneously as we all are living through it today. And it's just getting quicker and faster for us to be able to embrace it and to find solutions around these challenges. Ladies and gentlemen, our ASEAN has proudly been characterized, the region has been characterized by fairness, innovation, and at the same time dynamism. And in this spirit, I believe, amidst all these rapidly evolving global and regional landscapes, the 10th ACC that we all here gathered for becomes not only a platform for sharing our aspirations, it also becomes a catalyst to come together to create and identify those impactful actions. In closing, let me extend my heartfelt thanks again and gratitude to all of the distinguished speakers, all of you experts, and all the participants who have all contributed, coming together your time, your expertise to make this conference a reality. I really hope that the conversations here coming together that we are having are going to resonate beyond all these walls. And I also propose solid, sharp recommendations coming from everyone. Be open, be able to share your thoughts in shaping policies for the future for us, in helping us to foster better quality collaborations, and also helping us to identify high impact approaches to synergize competition and intellectual property regulation for the ASEAN. With that, let me wish you all a productive and enlightening conference.
A round of applause, ladies and gentlemen, for Deputy Secretary General Singh, leaving us with 3 questions to ponder on as we do go through day 1 and day 2 of the ACC. Now, before I introduce our honorable keynote speaker, allow me to acknowledge everyone who gathered here today, beginning with the Trade Competition Commission of Thailand's Deputy Secretary General, Manayos Vardanabuti. Good morning. Give us a wave, please. Hello. We also have Vietnam's Competition and Consumer Authority's Deputy Chairman, Ngo Doc Min. Good morning. Malaysia Competition Commission CEO, Iskandar Ismail. Competition and Consumer Commission of Singapore's Assistant Chief Executive, Legal Enforcement and Consumer Protection Division, Lok Shu Meng. Lao Competition Commission, Department of Internal Trade's Deputy Director General, Sai Thideth Inthasone. We also have the Australian Competition and Consumer Commission's Commissioner, Peter Crone. Hi, Peter. We have the National Economic and Development Authority of the Philippines Undersecretary, the Honorable Crystal Lin T. Uy. We also have the Embassy of Malaysia's Ambassador Extraordinary and Plenipotentiary, His Excellency Dato Abdul Malik Melvin Castellino. Royal Thai Embassy's Ambassador Extraordinary and Plenipotentiary, His Excellency Tul Traisorat. And the Embassy of the Lao People's Democratic Republic Ambassador, His Excellency Soneksay Vanaksay. Good morning and welcome to Manila. Thank you for being here for the ACC. And now, ladies and gentlemen, to set the stage for our keynote speaker, IP rights intended to encourage investments in research and development are granted to give exclusive commercial use to investors, promote innovation, and expand consumers' choices. Now, as stated in both our opening remarks, in some cases, however, the exercise of IP rights can become harmful if it leads to anti-competitive conduct. So here's another question for us to ponder on. Are the current IP and competition laws sufficient to prevent potential abuse of market dominance while still encouraging innovation? Today, we learn more on recent trends in local jurisprudence concerning these laws. It is now time to welcome our keynote speaker. Ladies and gentlemen, we have the Chief Justice of the Supreme Court of the Philippines, the Honorable Alexander G. Hesmundo.
Please be seated. With leave, let me dispense with the salutations and acknowledgement. Ladies and gentlemen, a pleasant morning to all of you. The judiciary, as guardian of the legal principles and people's rights, plays a crucial role in shaping the Philippine economy and society. through decisions which form part of the law of the land and the rules that ensure the proper exercise of government power in balance with the fundamental rights of citizens. The Philippine judiciary has defined a legal framework conducive to the development of a free, vibrant, and competitive market. After Republic Act No. 10667, or the Philippine Competition Act, PCA, was passed in 2015, the Philippine Supreme Court took no time in drafting rules governing the applications, issuance, and enforcement of inspection orders for administrative investigations of the Philippine Competition Commission. Through its constitutional power to promulgate rules concerning procedure in all courts, the Supreme Court bolstered PCC's role as a regulatory agency and gave teeth to its prosecutorial powers by ensuring that the power granted by law to PCC would be effective, objective, and efficient. Thus, not long ago after the PCC issued its implementing rules and procedure, the Supreme Court issued Administrative Matter AM number 19-08-06-SC, authorizing commercial courts to issue inspection orders on companies suspected of violating the Philippine Competition Act within 24 hours upon application by the Philippine Competition Commission. However, for the purpose of providing a balance between the fundamental rights to due process and the strong public interest involved in the enforcement of the Philippine Competition Act, the rules mandated the confidentiality of the application proceeding and set a period of effectivity of the order, detailed the process and the manner of inspection, and restricted the use of information collected therefore to administrative proceedings. 8 years hence, the state of competition law in the country and our aspiration for a more inclusive national growth may be examined through judicial decisions which clarified, defined, and explained the powers and the provisions of the PCA. The Philippine Supreme Court found the opportunity to define what was punishable under the Philippine Competition Act when it promulgated its decision in Geo Summer Incorporated versus Department of Transportation and Communication in 2019. In said case, the court found that the grant of concession agreement to an entity as a winning bidder for the exclusive development, operation, and maintenance of any or all of the projects does not by itself create a monopoly violative of the provisions of the Constitution. Bundling, therefore, projects for public bidding, as what was questioned in that case, does not ipso facto give rise to an anti-competitive agreement. What the law expressly prohibits is when an entity which has achieved a dominant position in a relevant market engages in a conduct in abuse of its dominant position. The following year, the PCC had a chance to argue its position in Philippine Contractors Accreditation Board versus Manila Water Company, where the constitutionality of an implementing rules and regulation provision reserving regular licenses for contractor firms of Filipino sole proprietorship or partnership or corporation with at least 60% Filipino equity participation and duly organized and existing under and by virtue of the laws of the Philippines was questioned. The PCC intervened as amicus curiae, declaring that it was doing so pursuant to its function to issue advisory opinions and guidelines on competition matters and to advocate pro-competitive policies of the government. Hence, here the PCC eloquently explained that the nationality requirement imposed under the ASEAN provision of the IRR erects a substantial barrier to the entry of foreign contractors in the construction industry. As a minority participant in the entity, a foreign firm exposed to the risk of pursuing major management decisions over which it does not have full control. The ASEAN provision results in a scenario where foreign firms are deterred from investing in the Philippines as they do not have the comfort of having full control and management over their investments unless they are able to find a reliable local partner. incipiently explaining the scope of governmental acts that can possibly restrain competition, the PCC declared that such an act can range from laws passed by Congress to rules and regulations issued by administrative agency and even contracts entered into with the private party. A more comprehensive competition policy embodied in the present Constitution empowers the Court to nullify both public and private acts that restrain competition. The Court in that case nullified that question provision. Truly, courts have a significant role in promoting a fair and competitive market by interpreting the law consistent with its avowed policy and by breathing life into their text through judicious application. It is essential for courts to adopt a dynamic interpretation to reflect the changing economic landscapes and also technological advancement. The purpose of our competition law is essentially to promote competition and stifle market domination for the benefit of the public. In that respect, the Supreme Court of the Philippines has not been remiss in promoting an environment of competition in a free market. Empowering local innovators while fostering a competitive domestic market is another area where the judiciary can contribute significantly. Truly, it has been advanced that by protecting the rights of local innovators, courts can encourage homegrown research and development, reducing dependency on foreign intellectual property. While there has yet been no case decided by the Supreme Court on the protective nature of IP rights vis-à-vis the principles of fair competition under the Philippine Competition Act, issues for judicial consideration seem inherent. In such cases, the judiciary's role becomes central. Court must strike a careful balance interpreting laws in a way that safeguards IP rights while at the same time preventing their misuse in creating monopolistic or anti-competitive market conditions. Against the backdrop of legal principles and broader policy objectives, the judiciary should be deeply aware of the socio-economic implications of its decisions. The role of the judiciary, thus, as regards our economy, is not a passive one. It is not merely about adjudicating disputes. Through its decision, it creates a legal landscape that will foster economic growth and ensure that the fruits of progress are equitably shared amongst all members of the community. I wish you all the best in today's conference. Thank you and good day to all.
Thank you very, very much to our Chief Justice Hesmundo for that keynote message. Chief Justice, may I invite you for a photo opportunity here, please, with, of course, Chairperson Aguinaldo. May we invite as well what a wonderful keynote speech. Thank you very, very much. Chairperson, would you like to invite also other VIPs to join us for the photo? But first, let's have both of you first. Please smile, gentlemen. Smile. And now, upon the invitation of Chairperson, may we invite all of our special guests, everyone, to our from the different countries, lead agencies. Please do join this photo opportunity. Come on. All our ambassadors, Your Excellencies, please join us. Ladies and gentlemen, joining us today also from the Hong Kong Competition Commission, we have the Chief Executive Officer, Rasul But, and the Head of Competition of Consumer Protection and IPR Division of the ASEAN Secretariat, Tang Von Luong. Good morning and thank you for joining us. Everybody squeeze in, please. Thank you for indulging us this photo opportunity. We decided to have it here versus on stage because we do have quite a delegation today. Thank you very, very much again to our dignitaries and to our keynote speaker. A round of applause once again for Chief Justice Hesmundo. Thank you very, very much. We do have a quick morning break. We invite you all to please take a cup of coffee, stretch, help yourselves to some snacks outside. Our first session will begin in 15 minutes. We will resume the program in 15 minutes. For now, please do enjoy the coffee break, and we will send out a reminder in a short while. Thank you. Good morning, everyone. We're hoping you are enjoying the coffee break. The program will resume shortly, hopefully on time at 11 a.m., if not a little bit earlier. So again, we invite everyone to please come back inside the Forbes Ballroom and settle down shortly. Thank you very much. Once again, good morning, everybody. We hope you all enjoyed your longer coffee break. But now it is time to resume the program. And after getting that coffee and some morning snacks, I hope everybody's ready to listen. Before we do proceed to the first session, here are some reminders on the format of our 10th ACC. We will have 5 sessions distributed throughout today and tomorrow. Today, we will tackle the first 3 sessions entitled, number 1, Advancing Merger Control and IP Regulation in ASEAN Pharma Markets. Number 2, Combating Anti-Competitive Practices and Licensing in ASEAN Pharma Markets. And number 3, AI and IP in digital platforms, a future competition issue. These are the first 3 sessions for day 1. Then after lunch this afternoon, we will have a brief launch of the peer review report on Malaysia's advocacy programs. We hope you're looking forward to that. And just in case, here's a heads up on what's happening tomorrow. The last 2 sessions are entitled Seeds of Innovation, Promoting Market Access in Biotech Through Competition. And the final session will be entitled Technology Transfer and Competition. So with that said, let us now lead on to our first session. And how it will go is this. A moderator will lead the session, followed by presentations from each of the panelists. There will be an opportunity for you, our audience members, to send questions during the Q&A, but you'll be doing this online via Slido. Please take a look at the screen. We do have a QR code for you. Please do scan this QR code or open your browser and type in the link slido.com, then the number 2478439 and click Join Event. Please type in your questions for the panelists per session, and our moderator will get to ask those questions to them within that session. Thank you. We'll give you a moment. Scan the QR code. This is your way to engage in the discussion today for the first 3 sessions. Type in your questions, please. We hope you're all in Slido. All right. Without further ado, here is our first session today, and here's the overview. Mergers and acquisitions in pharma markets often arise from various strategic objectives, including market expansion, product diversification, and of course, innovation. On one hand, these motivations advance consumer welfare by creating innovative medicine and providing more options for patients. On the other hand, IP asset management can be significantly altered during mergers and acquisitions, which can lead to the enhancement of a merged firm's market power, giving it the ability to unjustly exercise leverage over existing competitors and potential entrants. So this first session aims to discuss how ASEAN member states can use merger control as a policy lever in resolving anti-competitive concerns arising from mergers and acquisitions involving IP transfer in pharma markets. To moderate this first session, we have the Commissioner Ferdinand Negre of the Philippine Competition Commission, who I'd like to invite on stage with our panelists for a quick photo op. Good morning, Commissioner. Attorney Jose Maria Ochave, President of RightMed Philippines and Senior Vice President of Unilab Inc. Undersecretary Crystalline Uy of the National Economic and Development Authority. And we have 2 panelists online joining us from Geneva and Belgium. Let's flash them on screen. We have Mr. Anthony Taubman, Director of Intellectual Property Division at the World Trade Organization, and Ms. Vasilika Dolka, Case Handler at the European Commission DG Competition. May I ask my moderator and panelists to step forward for a group photo op? And shall we flash our online panelists on screen? We'll always have a quick photo op before the actual session begins. I have no doubt the discussion... There you go. Hi, Ms. Vasilika. We see you. May I ask you to smile also, Ms. Dolka?
Hello, good morning.
Good morning. Please smile. You're joining the photo op happening in Manila. We can all see you and you look lovely. Thank you. Commissioner Ferdinand Negre, please do the honors and take it away. We'll see you in a bit, Ms. Vasilika.
Hello. Thank you, Ms. Isa. To all our distinguished guests, good morning.
Morning.
Thank you. I like that. Welcome once again to the 10th ASEAN Competition Conference. Again, my name is Ferdinand Negre of the Philippine Competition Commission. I will be your moderator in this session 1 entitled Advancing Merger Control and IP Regulation in ASEAN Pharma Market. Traditionally, I want to emphasize traditionally, intellectual property law and antitrust or competition law have been seen as opposites. That premise is grounded in the paradigm that IP law primarily protects the exclusive rights of innovators, creators, and businessmen by granting them patents, copyrights, or trademarks for their sole benefits. From a certain point of view, these exclusionary benefit granted by the IP law to the patent holder, the trademark owner, or copyright holder is a form of monopoly power. Actually, more for the patent holder. In fact, in one case, I think that's the case of DuPont versus Francisco, our Supreme Court held that patent is a monopoly. But to be more precise, that is legal monopoly. That's not economic monopoly that we know. But monopoly power nonetheless. In monopoly power, the patent holder may refuse to license or allow the use of his or her patent, copyright, or trademark to a third party, thus depriving others of the possible benefits of using such creation as an input in the value chain for goods and services. By its nature, monopolies are generally at odds with antitrust or competition law. However, the concentration of market power or market dominance by itself and in itself is not a violation under the competition law, especially if this is acquired using valid and legal means. Under most competition regimes, there are three pillars of enforcement, namely anti-competitive agreements, abuse of dominant position, and anti-competitive mergers and acquisitions. The first two pillars are ex post mechanisms, meaning when a conduct or agreement considered to be anti-competitive has already been consummated or committed. The third pillar is on anti-competitive mergers and acquisitions, which is an ex ante mechanism to ensure that M&As will not lead to a substantial lessening of competition in the market concerned. So, for this first plenary session, we will focus on the ex ante mechanism on M&As and how this can advance IP regulation in ASEAN pharma markets. Our first speaker is Attorney Jose Maria A. Ochave, or Joey. Joey is president of RightMed Philippines, Inc., and Pharex Healthcare, Inc. He's chairman of the board of Ambika International Trading Corporation and heads other business units under the United Health Group. He's also senior vice president in Unilab, in charge of business development, legal services, external affairs, and regulatory affairs. He is currently member of the CHED, or the Commission on Higher Education, Technical Panel on Pharmacy and Education, private sector representative in the Governing Council of the DOST. DOST is our Department of Science and Technology, Philippine Council for Health Research and Development, trustee of the Philippine Institute of Pure and Applied Chemistry at the Ateneo de Manila University, industry advisor of the DOST Industrial Technology Development Institute, member of the Private Sector Advisory Council in Healthcare Working Group, and trustee of the Philippine Science High School Foundation. He was legal advisor of the National Committee on Biosafety of the Philippines and the DOST Biosafety Committee, member of the Civil Law Faculty of the Philippine Judicial Academy of the Supreme Court of the Philippines, and lecturer at the UP College of Law and UP College of Engineering. He continues to lecture in various conferences and fora in the areas of healthcare and intellectual property rights. Joey obtained his Master of Laws degree from the University of Michigan at Ann Arbor under a Clyde DeWitt Foundation Fellowship. He received his BS in Bachelor of Science in Chemical Engineering and Bachelor of Laws degrees from the University of the Philippines, Diliman, both under scholarship grants. He graduated salutatorian at UP Law School, where he was Chancellor of the Order of the Purple Feather Honors Society. He ranked 7th in the 1986 Chemical Engineering Board and 11th in the 1992 bar examinations. There are more. I'm not going to read everything, Joey. Ladies and gentlemen, Joey Ochave.
Thank you. Thank you very much, Commissioner Negre. I hope you don't mind if I stay down because I'm not used to speaking behind the podium. Okay. That was a very long introduction. Anyway, thank you. This is my 24th year in the pharma industry, 22 years of which, the last 22 years of which, I've spent going around the world, looking and visiting various manufacturing facilities. So I've visited more than probably hundreds of manufacturing facilities and negotiated contracts on behalf of Unilab. Now, I just have 10 minutes. I'm usually used to lecturing for about 3 hours straight, but I'll try to finish this. It doesn't work. Sorry, I need help. Oh, there. Essentially, we all know this. Patents are essential in the pharmaceutical sector. In this particular sector, patents are very essential. It provides economic incentives, as you all know, for pharmaceutical companies to develop new drugs, given the financial risk associated with developing new chemical and biological entities. Okay, regardless of which estimate you believe, whether it's a Tufts University estimate in terms of drug development, or whether it's the R&D spend, Big Pharma from 1994 to 2000, it's expensive. And that's the reason why you don't have new chemical entities, generic companies producing new chemical entities in Southeast Asia or anywhere in the world. The only big generic company that did so and was successful globally was Teva of Israel. But in creating a temporary monopoly, and we all know this, for the patent owner, patents unavoidably have an adverse impact on market competition. This is an example. This is data in 2006. All those in red are all protected by patents at that time. Okay, 2006. So, and all of them are actually patents held by Big Pharma here in the Philippines. These are molecular patents, not formulation or salt patents. Now, given that situation, way back in 2006, this is how it costs. Medicines are expensive in the Philippines, and even more so during that time. If you look at the amlodipine benzoate, this is your Norvasc, okay, for those who have hypertension. In the Philippines, it was being sold at 5 milligrams, 44.75 pesos. The same molecule being sold in India by the same company is being sold in India by the amount of equivalent to 7 pesos 20 centavos. The same molecule then being produced in India by a company that exports to the US and EU was selling it at retail at 3 pesos 15 centavos. So that's the disparity in terms of costs, in terms of prices. Clopidogrel, which is you take if you had a stroke and you'd have to take this every day, this is Plavix. Okay? The originator was selling it at that time at 120 pesos per tablet. The same generic in India at the time being sold by a company that exports to the EU, to UK, and to US, being sold at 6 pesos 43 centavos. So if anyone tells you that IP has no impact in terms of pricing, medicine pricing, the fellow is living in La La Land. Now, I always tell people, IPRs this is really an instrument of national policy. Then you have to know what you're walling in, what you're walling out. This is the number of local patents in pharma at that time. As I said, new chemical entities are very, very difficult and very expensive to develop. There is, however, having said this, there is as yet no system than what we have at present, imperfect as it may be, that balances the economic interests of the innovator, of the inventor in particular, in exchange for access to inventions that may be useful to society. For those in you in the IP practice, this is the usual incentive access paradigm. There is, of course, always the risk of rent-seeking behavior on the part of the patent owners. And this is addressed in the Philippine Constitution, in Philippine jurisprudence, and Philippine legislation. I am not aware of any other country other than the Philippines and the United States where intellectual property rights protection is part of the Constitution. The only difference between us and the US is there is a beneficial to the people proviso. So even with the IPR, you have to look at it from the prism of, is it beneficial to the people? And even our jurisprudence says so. This is a decision of Justice Corona in 2003, and it says, when a patent is issued, the limitations on its exercise are strictly enforced. So even the Supreme Court is very much aware of the potential harm that unrestricted patent protection can do. And of course, we had in 2008 the Cheaper Medicines Law, which provided public health flexibilities in our patent law, which surprisingly was not part of our intellectual property code. When all these public health provisions are also present, were also present in the US, in Japan, in EU legislations. So unfortunately, in the Philippines, surprise, surprise, there were no public health flexibilities when we had the law amended in 1998. So what the Cheaper Medicines just did was to insert the public health flexibilities in our patent law. This is the virtuous cycle of pharmaceutical development. You know, you have drug discovery by Big Pharma, new drug. There's a patent protection to enable them to recover the investment, recovery of R&D investment, and then the role of the generics will enter with cheaper, affordable, and hopefully quality versions. So this is the virtuous cycle, and it should happen. However, sometimes it doesn't happen, And one example here is actually what happened to telmisartan. This is Bicardis. This is a Boehringer Ingelheim. But this is not the fault of really Boehringer. It was the fault of our own law. When we shifted from the old patent law to the new law, it provided, before Philippines was on a first-to-invent system, just like the United States, which means that the patent term extends from 17 years from the time the patent is issued. Unlike the first-to-file system, which is 20 years from the time you filed the application. In this case, the people were granted, okay? In this case, the molecular patent for telmisartan was filed in 1992. The letters patent were issued in 2005. And of course, as any good patent lawyer will do, he would want to be governed by the old patent law of 17 years for patent application. As a result, this patent here in the Philippines expired only 2022, when it was already expired everywhere. Unfortunately, this same company did not lower its prices for the product here. Despite this is 30 years protection, did not lower the price, and it took the government, when it did the price control, to make them force to lower the price. So medicine patents are sui generis because of their impact on access to essential medicines. Even the WTO says so in the Declaration on TRIPS and Public Health, the Doha Declaration. And this is the Doha Declaration. So this is public health trumps intellectual property, at least insofar as the Doha Declaration is concerned. But obstacles to competition are not currently due to patents anymore. So patents are, because one, most countries in ASEAN already have the public health flexibilities in their own respective laws. And this was a campaign we did together with some of our ASEAN counterparts way back in the early 2000s. Together with NGOs like the Third World Network and Oxfam, and Médecins Sans Frontières, and WHO also, the international organization. And molecular patents of most essential medicines that are needed for public health at the moment have already expired. Okay? The problem now is sourcing. Because you can have no patent here, there will be no infringement, but if you cannot source the product elsewhere, there's no product. And that was the value that India provided in the early 2000s. But in 2005, when they had the product patents, India did not become a source anymore of all these new products. Now, the potential source is Bangladesh as an LIC country. And I visited Bangladesh, and 98% of their domestic requirements for medicines are already produced in Bangladesh. 98%. And they have already EU GMP certified and US FDA certified plants, and they're starting to export to US, MHRA, UK, and the US. So, sometimes the distortions, where are the distortions now in terms of competition? You have to look at the value chain. Each country here has different value chains when it comes to pharma because we have different healthcare systems. Philippines is out of pocket healthcare system. Most of the countries here, except probably Indonesia, most of the countries here are reimbursable system. So the dynamics are very, very different because of the existence of the big third-party payer. So if you want to look at competition, the money now is not really in manufacturing, at least in the out-of-pocket systems. It's in the other areas. However, in the light of the COVID-19 pandemic, most countries now look at reliability of drugs and vaccines as matters of national security. And this is why local manufacturing is seen now as extremely important, not only to address future pandemics, and there's another one in China now, in pneumonia, but also to support universal healthcare initiatives. This is in one slide, how medicine prices are impacted. And that is why competition law plays a very, very big role. Because if you have monopolies, then necessarily the prices go up. Now, competition is not competition per se. Competition is because you want to achieve something good, and this is social good. But you have to weigh competing equities. Right now, most countries would want to have local manufacturing in order to ensure their populations will have access to essential medicines in times of pandemic and to support public healthcare initiatives. So right now, you have Indonesia, which basically says this. Right now, Indonesia, the biggest market in ASEAN, pharmaceutical market in ASEAN, you cannot just enter, because there's a requirement of local manufacturing, which is good, because that's a policy decision that they made, that they need to develop their own local manufacturing so that they can assure the supply of their medicines. So that's a policy initiative. Most countries now have similar policies in various ways. So now, where the restrictions are, it's not in patents. It's in the regulatory framework. It's in policy decisions made by government. Whether they are good or not, whether they're conflicting with competition law or not, is another matter. But those are any competition person has to consider. Thank you.
Thank you, Joey. In time. Thank you for keeping in time. Thank you. And it is comforting to know that the high prices of medicines, and we all take medicines, I think, in this room, not necessarily. The high prices of medicines are not just caused by patents, or not even patent, but by other causes like regulatory processes. Because this is the first time I've heard of that, Joey, that it's not patent which is the culprit. Not now. Okay. There's the colatilia. Not now. Thank you. And you've talked about Doha Declaration, the TRIPS Agreement. That leads us to our next speaker, Mr. Anthony Taubman. Anthony Taubman is currently Director, Intellectual Property Division of the World Trade Organization, with responsibility for the WTO's programs on intellectual property, competition policy, and government procurement. From 2002 to 2009, he was Director, Global Intellectual Property Issues Division of the World Intellectual Property Office, covering a wide range of programs on intellectual property and genetic resources, traditional knowledge and folklore, the life sciences, and related global issues, including the environment, climate change, human rights, food security, bioethics, and indigenous issues. After a diplomatic career, he left the Australian Department of Foreign Affairs and Trade, or DFAT, in 2001 to join the newly formed Australian Centre for Intellectual Property in Agriculture at the Australian National University, teaching and researching on international IP law. From 1998 to 2001, he was Director of the International Intellectual Property Section of DFAT, and in that capacity he was engaged in multilateral and bilateral negotiations on intellectual property issues, domestic policy development, regional cooperation, and TRIPS dispute settlement. He authored a training handbook on intellectual property and biotechnology, a monograph on the TRIPS agreement. Incidentally, when I was still in the private practice of law, I often consult his book on TRIPS agreement. And comprehensive study on its implementation, a range of academic and general publications on international intellectual property law and policy. Postgraduate teaching appointments at several universities include curriculum design and teaching at the University of Melbourne, the Australian National University, and Queensland University of Technology, as well as numerous contributions to other educational training programs in many countries. In 2008, the Rockefeller Foundation awarded him a Bellagio Residential Fellowship for his work on TRIPS and public policy issues. He worked previously for WIPO from 1995 to 1998. His duties then including development cooperation in Asia and the Pacific, the development of revised WIPO program and budget, and associated policy development. A registered patent attorney, he worked in private practice in the law of patents, trademarks, and designs in Melbourne. His tertiary education has included computer science, mathematics, engineering, classical languages, philosophy, international relations, and law. And as clincher, he has taught ancient Greek philosophy at Melbourne University. Let's welcome Anthony Taubman.
Hello, warm greetings from a rather chilly Geneva, Switzerland. I'm delighted to be able to join you for this, the 10th ASEAN Competition Conference. I'm only sorry that I can't be there in person, because the issues you're looking at, the conversations you're having throughout this conference are enormously interesting and I think very important, not only for your region, the ASEAN region, but for international dialogue and cooperation well beyond the region. This is why I was really thrilled to receive the invitation to take part, for which I thank the organisers very much. These are very topical issues, important issues for today, but they do have deep roots internationally and indeed in the development of law more generally. In the common law tradition, it was exactly 400 years ago, 1623, that the Statute of Monopolies was framed by the English Parliament. While it's often presented as the first patent law, if you like, in that system, it was really an element of competition policy, and the concern was to limit the scope and impact of monopolies at that time, to ensure that they weren't burdensome on the public, to ensure they didn't impede legitimate trade. Competition policy considerations. And turning to the international framework, when the League of Nations was looking at economic issues in the 1920s and 1930s, the issue of equitable treatment for commerce across the membership was very much on the agenda. And in the 1940s, when the GATT, the General Agreement on Tariffs and Trade, predecessor to my organisation, the World Trade Organisation, was under development, these issues also were considered. The so-called Havana Charter from the UN Conference on Trade and Employment set out a far broader framework for international economic cooperation, and here, under restrictive business practices, it proposed measures taking on anti-competitive practices or restrictive business practices that involved either the prevention of the development or application of technologies or inventions, whether patented or unpatented, and what we would now call, I suppose, vexatious litigation, or the abuse of infringement claims to impede legitimate business activities. So this was in the frame even in the late 1940s, even though in a formal sense this did not come into force. Then we move forward quickly to the negotiations for the World Trade Organization from 1986 onwards. These, of course, included negotiations on so-called trade-related aspects of intellectual property rights. And one of the issues was exactly what are the trade-related aspects of intellectual property rights, with an increasing focus on competition policy as one of the elements. And references to competition policy do thread their way through the negotiations on the TRIPS agreement, on our intellectual property agreement. For example, here's an exchange with New Zealand discussing when compulsory licensing should be used as a remedy for anti-competitive practices. And the essential point made by New Zealand, at least, is that you really have to take what we would call a rule of reason approach. Look at the circumstances of each case to determine whether really there is an anti-competitive impact, rather than what we would call a per se approach, that is to say, a list of specifically excluded practices. Again, a debate that continues right through today, but a reminder that these issues were very much at the forefront of the considerations that went into the TRIPS agreement. And when we turn to the actual TRIPS agreement, the WTO agreement on intellectual property, you'll see, of course, a level of principle, a reminder that the protection of intellectual property is part of an approach of reducing distortions and impediments to international trade. It is a trade agreement after all, but also a concern that enforcement of intellectual property rights should not itself become a barrier to legitimate trade. And tracking right back to that concern about inappropriate litigation, for example, or claims of infringement. And when we look at the objectives for intellectual property protection as set out in the TRIPS agreement, there is this reference to a balance of rights and obligations. And in the simplest terms, I think there's no doubt that competition policy safeguards are one of those critical balancing factors that are there to ensure that the intellectual property system really does deliver on its promise to support social and economic welfare. This is even more explicit in the following article on principles, which is a reminder that the negotiators of the TRIPS agreement certainly saw a role for governments in taking action to deal with the abuse of intellectual property rights, precisely because they could restrain trade or adversely affect the international transfer of technology. Still a major concern, of course, and a reminder that competition policy, while focused on the domestic jurisdiction, does have important implications for economies and trade and transfer of technology beyond individual jurisdictions. So an interplay here between competition policy as a domestic-focused set of policies and trade policy, considering the interaction between different jurisdictions. And we have seen in the implementation of the TRIPS agreement and discussions since then an increasing focus on these interactions. When we turn to the specifics in the TRIPS agreement concerning patents, there's a clear expectation that that government should have scope to override the exclusive effect of patent rights as one of the potential responses to anti-competitive practices, as they're hardwired in the agreement. And there's an additional interesting provision, which I think has been somewhat neglected, a dependent patent, a patent that can't be really exploited without infringing a prior patent. There is provision for mandatory cross-licensing on reasonable terms, which to me is an important way of governing the competitive relationship between two rival firms, if you like, both of which have introduced valuable new technologies to the public. Another aspect of competition policy that I think it's interesting to explore is that of unfair competition, which is often put in a separate zone. It's classed as a form of intellectual property in itself. But it is there in the TRIPS agreement as the basis for the protection of undisclosed information, and it's linked to the Paris Convention, the WIPO Convention on Industrial Property, and a reminder that there are specific obligations to protect against unfair competition, and this is construed in very broad terms. And I like to consider it as part of the competition policy objective of ensuring that the competitive relationship between firms ultimately serves the public interest. Indeed, Stephen Ladas, the leading scholar on international intellectual property, makes this comment that unfair competition constitutes the general principle of which the laws protecting the various branches of industrial property are only special aspects or particular applications. So an overarching unifying principle, if you like. At least that's how it's seen there. And indeed, the TRIPS agreement provides for measures against anti-competitive practice in contractual licenses. There's a firm agreement that at this level, at the treaty level, that there are licensing practices or conditions that do restrain competition and have that international effect, that the adverse effects on trade and the international transfer and dissemination of technology. This, however, was not an obligation. It was simply a permissive measure that marks out the scope for member governments to take action. And there's a list of possible anti-competitive practices that governments may choose to take action against. Interestingly too, there's a provision for international cooperation. This is a mandatory provision, this is an obligation for countries to cooperate in the enforcement of competition policy in relation to restrictive licensing practices. Curiously, this I think has been rarely, if ever, used effectively, and it'd be an interesting model to look at across the ASEAN region. This is why technical cooperation in this area is part of the TRIPS package. There's a wide scope of obligations on technical cooperation. This includes working towards the prevention of the abuse of intellectual property rights. There's also scope for our council, the Council for TRIPS here in the WTO, to look at these issues, and indeed recently South Africa put this on the agenda, and there was a discussion in particular concerning competition policy and the promotion of public health vis-a-vis the intellectual property system. I think an important conversation, but again I think this avenue for dialogue really hasn't been used to its full extent. It's not as though these issues are not important, and of course we saw this very directly in the COVID pandemic. So where does this bring us today? Well, I'd like to mention just a few issues that we've dealt with at a working level in the WTO in cooperation with our colleagues in WIPO. This book was published to provide a sort of a platform for international dialogue and collaboration, looking at current issues from a broader global perspective, with a particular focus on the developing world. And indeed, one of the most interesting chapters is a survey of practices concerning intellectual property and competition policy in a number of jurisdictions, established jurisdictions, and those jurisdictions with quite new competition authorities. The issues looked at really represent an agenda for international dialogue and collaboration, in my view. The licensing practices, the approach taken to measuring effects of anti-competitive practice or claimed anti-competitive practices, the threshold for refusal to license, when is that anti-competitive, anti-competitive patent settlements between originators of pharmaceuticals and generic follows-on, standard essential patents, patent association entities, and of course the role of competition authorities in advocacy for a more healthy relationship between competition policy and intellectual property. We're also seeing a sharp increase in the number of regional and bilateral agreements that have competition policy provisions, reminding us that there is an emerging international law of competition policy through these agreements, which we need to take greater attention to. So to conclude, I think the situation we are in is that many countries now have if you like, the hardware in place. The competition authorities have been established, the legislative framework has been laid down, and there is the hardware is established to do important work of monitoring, setting guidance, and enforcing competition policy. But in many cases, we're still, if you like, developing the software to make that hardware work. In particular, the approaches taken to assessing anti-competitive conduct and the forms of methodology that can be applied in putting the rules to work. So when it comes to international dialogue and sharing experience, these are the issues that we would suggest prioritising. Looking at the methodology for assessing anti-competitive impact of the exploitation of intellectual property rights. Do you apply a rule of reason approach, or do you have a list of known no's, as it used to be put? What's the threshold for refusal to license? When does that become anti-competitive? Increasingly concerned about the anti-competitive effects of merger and acquisition, when entire portfolios are acquired, intellectual property portfolios are acquired through merger and acquisition, potentially creating anti-competitive market dominance. And indeed, the question of excessive pricing, when is this an issue for competition policy? We've seen this again arising in the COVID pandemic, and this long-running debate about when is it okay for an originator and a generic pharmaceutical firm to settle a patent case and thereby potentially depriving the public of the benefits of generic competition. So just a few quick ideas for you to reflect on, and I'm very eager to continue the dialogue in other ways. So if there are ideas for follow-up and further cooperation and dialogue, we're all ears. Thank you so much for your time and your patience.
Let's thank Anthony for that presentation. I think it has provided a very good background on the interplay between patents and competition law and policy, what we call a trying to reach that harmonious balance that we have talked this morning. I think it was Mr. Singh who mentioned that this morning, and also trying to address the common objectives of economic growth and consumer welfare. Talked about compulsory licensing, abuse of IPRs, licensing practices that should be the grounds, the common grounds in harmonizing patents, the seemingly opposing objectives of patents and competition law and policy. He mentioned about licensing. I would like to mention here at this stage that in one case that the Philippine Competition Commission decided, the Commission required the terms that must be included in a merger acquisition or a merger agreement is what we call the FRAN terms. And speaking of FRAN, we're referring to fair, reasonable, and non-discriminatory terms. And speaking again of mergers, we now have our next speaker, Undersecretary Crystal Uy. Crystal obtained her Bachelor of Arts degree in Political Science from the Ateneo de Manila University and finished her Juris Doctor degree in the University of the Philippines. In 2019, she obtained her MA in EU Competition Law in King's College London with distinction. She also obtained in 2021 an LLM on Innovation and Technology Law from the University of Edinburgh. She was admitted in the Philippine Bar in 2011 and was ranked number 7 in the 2010 bar examinations. Attorney Uy Crystal, worked as a litigation and corporate attorney before joining the USAID Trade-Related Assistance for Development Trade Project as technical legal assistant for competition, where she worked on the implementing rules and regulations of the then newly enacted Philippine Competition Act. From the creation of the Philippine Competition Commission in 2016, she has held the position of Director for, that's the head, of the Mergers and Acquisition Office of the Philippine Competition Commission. Crystal is now the Undersecretary for Legislative Affairs at the National Economic and Development Authority. She is also a lecturer at the UP College of Law and Manuel L. Quezon University College of Law. Attorney Crystal published several papers. One, the Philippine Antitrust regulation relating to minority shareholdings. Is there an enforcement gap? Published in the Philippine Law Journal. Two, adapting telecommunication regulation to competition, a selection of key issues for reform in the Philippines, published in the Asian Journal for Comparative Law, Cambridge University Press. Three, a handbook on the Philippine Competition Act, an introduction to Republic Act number 10667, UP Law Center, and Philippine Telecommunication Laws and Regulations, a TPP gap analysis. Let's welcome Crystal Oy, please.
Thank you, Com Negre, for that warm introduction, which is very complete. I would like to share with you my experiences as the first director of the PCC Mergers and Acquisitions Office, specifically on challenges that we had to navigate in asserting mouse authority in a jurisdiction that is actually new to competition. So with respect to pharmaceutical mergers, PCC actually has not had a lot of cases. I remember that we had one of the first cases was Sanofi Boehringer, and we also had GSK Pfizer like a few years back. So first, in pharma mergers, of course, you need a lot of information. And that is always a challenge when trying to communicate to your stakeholders why you need all of this information. And there's a lot of discussions that is needed for the parties to kind of like have an understanding on where we're going, what track we are going to take, how the review is happening. And so that back and forth is, of course, it's fun, but it's also very challenging. So another one is defining the relevant market for pharmaceutical mergers. I remember back when we were doing the GSK Pfizer, we can't rely specifically on the use for the particular drug, the molecular use, for example. But there are other factors that shape demand characteristics in the market. So you look at advertising or marketing materials of the pharmaceutical companies, and you also look at how the doctors actually prescribe certain medicines. And all of these shape that demand. So it's not a straightforward definition that, okay, this one treats this particular disease and obviously it's competing with this other one, because it really depends on these other factors that I mentioned. We need also, another challenge is, of course, the notification of these particular transactions. So these transactions are, it can happen that the product has not yet been commercialized, that it is still in research and development, or maybe it's in clinical trials. So the future competitive significance of the target firm may not accurately be reflected in the notification thresholds. And so the notification thresholds as designs in the size of party and the size of transaction may not capture these transactions. So I note in the Bundeskartellamt and also the JFTC has already made a modification on the way that they design the threshold to be able to capture transactions where the target firm has a lot of potential, or they're doing a lot of innovation in a particular market, but it has not yet been commercialized, and therefore it's not reflected in their gross revenues or the size of their assets. So I specifically for Bundeskartellamt, I note that what they did is they put in the size, the purchase price as one indicators for them to be able to capture these particular transactions. And another challenge, of course, is the uncertainty when you're looking at innovation markets. In the GSK Pfizer case, we specifically looked at loss of innovation as one of the theories of harm in that particular case. This was later dismissed because most of the products in question are off-patent products anyway, and there's really no new developments in the pipeline. But you can imagine a situation where the transacting parties would have competing pipeline products. Or another one would be both of them are innovation drivers in the particular industry, and the transaction would actually result in the loss of prospective innovation in this market. So another issue, if you look at the recent, the 2018 Cunningham paper, the paper actually looked at pharmaceutical merger data and found that there's a tendency for these transactions, if there's an overlap between the R&D efforts or the pipeline product of the target firm, to discontinue, because there's a possibility that it can pose a future competitive constraint to the acquiring firm. So that's what they say, killer acquisitions. And of course, it's actually possible that a reverse killer acquisition could take place, that the acquiring party acquires that target firm specifically so that it will no longer have to develop its own product in the market, because the target firm already has that, and you lose that additional product variety and competition in the market. So this requires a lot of uncertainties. And it's especially difficult for competition agencies to kind of find evidence on what will happen in the future. And that's always a struggle. I mean, not just for this particular industry, but if you're talking about digital mergers or even other transactions in markets where, the conditions are fluid. It's not a very stable industry or market. So that's obviously one challenge, and I think that many of our colleagues with the other ASEAN member states share the same. I think we've discussed this in the past, but specifically in the technology sector. And another challenge, of course, is the enforcement issue. So assuming that, you have managed to conduct an investigation in a particular global merger, and then what happens? If you really find, anti-competitive issues in that particular case, are you really going to prohibit that transaction? And if you prohibit that transaction, what is the implication of that to the access to healthcare in the country? Especially since these are global transactions that are, their headquarters are in the more developed countries, and us in ASEAN, we are, small countries where we are kind of unsure yet in looking at all of the issues involved in this particular case, and how are we going to assert our jurisdiction or authority over this particular case. So I note that I remember in the past when we were looking at the Bayer-Monsanto transaction, there was a question there on innovation markets, and one of the issues that we were discussing was, is this something that we take into account? We know that the EU is looking at this, and they would probably impose remedies on this. So do we just free ride on the positive externalities that will bring to the region? And so that's of course always a struggle. And the last point that I would like to make in dealing with these types of transactions in the pharma markets would be the type of remedies that you would need to consider. I mean, obviously, if you've seen a lot of, and I think the next panelist will talk about that, there's a lot of divestment that has been prescribed by the competition authorities, and also remedies involving licensing to the patents, so that will allow other competitors that can develop and commercialize that particular technology and market it in the country could be one. That is a challenge, of course, because we're a young competition agency, and these are very technical issues that you need to deal with. You need to know the business, and you need to find possible, for example, in divestment, you have to find like a really good buyer to be able to have a successful divestment. So thinking about these issues could pose a challenge to competition agencies. So I think that that's it on my end. I can also discuss additionally the second question, but maybe we can do that later. Okay.
Please
And
proceed.
so there was another question on what role have mergers and acquisitions in the pharma sector has played in the country's economic development. So I would just like to flag that, as my panelist has said, this market is out of pocket, and this has big implications on access to healthcare, the prices, especially of medicine. So we note that in the Philippine Development Plan, subchapter 2.1, one of the key strategies there is to boost health of all Filipinos for the promotion of human and social development. And the key strategy for this is actually access to healthcare. And so the PCC has a big role to play, because you look at Chapter 10, and one of the strategies there is, in the pharmaceutical industry specifically, as stated, the PCC will continue to monitor and pursue an inquiry into possible anti-competitive practices that may exist in the different segments of the supply chain to ensure competition and improve affordability, quality, and accessibility of medicines in the country. So that's a key strategy for the country in looking at this particular sector. And from an M&A point of view, of course, as we said, prices of medicine is very important, and PCC has a lot of role to play in ensuring that prices, if there are transactions that would lead to a loss of competition and result in higher prices, then it's PCC's job to safeguard that. There's also a big role for PCC to play in ensuring that innovation remains protected, especially in this field, because innovation plays a critical role specifically in this in the pharmaceutical market. So that's it for me. Thank you.
Thank you, Yusek. Crystal, really appreciate you sharing the challenges that you have faced during your stay at the Philippine Competition Commission. We must understand that this is a new law for us in Philippines. It's a 7-year-old law. It's a baby. And in my 9 months of stay with the commission, I can share the sentiments of Yusek, Crystal, the challenges that they have faced at that time, that we still face until today, gathering information and data, very challenging. Defining the relevant market and the uncertainties. As you know, it's very difficult to read the future. As I mentioned earlier, this is ex-ante mechanism. So you have to predict what will happen in the future. Very, very difficult to do, despite all those economic analysis that we cannot really, pin down what will happen in the future. And of course, the enforcement and remedies challenges that mentioned by Yusek, Crystal, which I hope will be addressed by the best practices in another developed region, referring to the European experience. Our next presenter actually will talk about that. Ms. Vasiliki Dolka is a case handler at Unit D5 of the Directorate General for Competition of the European Commission, dealing with mergers in the pharmaceutical sector. Prior to joining the European Commission, Ms. Dolka practiced as a competition lawyer at several American law firms in Brussels, Belgium. She has obtained and practiced as a lawyer in a boutique competition law firm in Athens, Greece, as well as at the Hellenic Competition Commission in Athens, Greece. Among others, she has experience in the fields of pharmaceutical and medical devices, chemicals, and financial services. Ms. Dolka graduated from the National and Vasiliki, correct me, Kapodistrian University of Athens Faculty of Law in 2014 and has obtained an LLM degree in EU from the College of Europe in Bruges, Belgium, as well as a postgraduate diploma in UK, EU, and US copyright law from King's College, London. Let's welcome Vasiliki Dolka.
Hello, everyone. I hope you can hear me. Thank you very much for having me here, and thank you very much to all the panelists for the excellent interventions. Indeed, I will continue on the theme of merger control. I have a couple of slides. I don't know if you could help me put them on. Thank you. So yeah, as I said, I will continue the theme of merger control. I will provide a brief introduction on how we assess innovation competition in pharma mergers in the EU. As you will see in the next slide, before diving into the legal framework, I would like to provide a quick introduction of the life cycle of the pharma product. Mr. Chap already provided a very good explanation on that in his first intervention. So as you can see, patent protection plays a very important role. R&D is also very important. Pharma companies face very high development costs and invest a lot of money in R&D. And that's why it's very important for us as an EU regulator to be able to scrutinize such pharma mergers, especially because they have this potential to compromise research and development and prevent the launch of innovative products into the market. As mentioned before, as you see, pharmaceutical companies make the biggest chunk of the revenue upon the launch of the product, as they benefit from market exclusivity during the patent protection period. Once patent protection expires, we have the entry of generic competition into the market, and prices tend to go down. Now, what we often see is that when the patent protection of blockbuster products of big pharmaceutical companies is about to expire, companies tend to turn to M&A in order to ensure the future growth. And when we actually look at those deals, what we see is that the target companies have products in various stages of development. So either marketed products or a portfolio of many times promising pipeline products. And this is why when we are reviewing these transactions, what we look at is not only the market-to-market overlaps between these companies, but also the market-to-pipeline and also the overlaps between the ongoing pipeline programs between those companies. Now, in the pharmaceutical industry, the process of innovation is structured in such a way that it's actually possible for us to identify already at early stages the competing clinical research programs. And as you probably will know, the phases of clinical development for pipeline products is as follows. We have a phase 1, which is the phase where a drug is firstly used in humans. And at that phase, what we try to confirm is the safety, that the drug can safely be used in humans. Moving on to a phase 2, where these studies explore the therapeutic efficacy in patients. And then if phase 2 is successful, the drug moves to a phase 3 before it's been approved, which aims to demonstrate the therapeutic benefiting of a larger group of patients. Now, as I will explain in further detail shortly, when we are reviewing a merger, it's very important that we look at all the pipeline products on all the various phases, phase 1, phase 2, and phase 3. However, it's true that when we're reviewing mergers with early stage pipelines, there's a lot of uncertainty as to the future use and the actual product market where this pipeline will compete in the future. Now, moving on to the next slide and to the legal framework that actually empowers us to review innovation competition, our horizontal merger guidelines, so the detailed framework we have at our disposal to review horizontal transactions, specifically refer to the effect on innovation as one of the elements to be assessed in merger control, and assimilating this effect on innovation to other competitive causes of harm, such as price increases, reduction of output, or reduction of quality of the goods and services. Now, in Europe, the first time we actually intervened in a pharmaceutical merger concerning pipeline products was the acquisition of GSK's oncology business by Novartis in 2015. We were actually concerned in this case that Novartis would have a reduced incentive to bring some of its R&D products into the market, mainly because both Novartis and GSK had duplicative clinical programs. And as hinted at by the previous panelist, indeed, we approached this by imposing a remedy. So we authorized the transaction conditional upon the divestment of one of the two duplicative programs to competitors. In this case, it was Array and Pierre Fabre. Now, after 2015, 2 years later, in 2017, the Commission developed what we call a 4-layer analytical framework when assessing potential innovation competition. The previous panelists also hinted at that. This would be the Dow, DuPont, and Bayer Monsanto cases. And we actually have been using this analytical framework to assess innovation competition ever since in all types of transactions. Now, what is this 4-layer assessment? The first layer is actual competition. So at this stage, what we're looking at is overlaps between the parties' existing marketed products. So that layer is a classical horizontal overlap theory of harm analysis. Now, moving on to the second layer and our next slide, we are looking at potential product and price competition. So at this level, what we assess is the overlaps involving advanced stage pipelines, either phase 3 or phase 2, depending on the data that we have at the moment, which can overlap either with a marketed drug or with another pipeline drug. So when we are in this scenario, the relevant factors that we look at are what are the adverse effects on prices, if we assume that the merged entity would be bringing both products into the market, and of course, the likelihood of discontinuation of one of the pipeline products, which could lead to higher prices and a reduction of choice for consumers. And in 2020, to give you an example, in the acquisition of Allergan by AbbVie, we saw this pipeline-to-pipeline competition scenario where both companies had advanced pipeline products for the treatment of inflammatory bowel disease. And here, the concern was that post-transaction, AbbVie would have an incentive to actually discontinue the development of Allergan's pipeline product. In order to alleviate these concerns, we authorized this merger conditional upon the divestment of AbbVie's pipeline product to a competitor. Now, moving on to the third layer. The third layer concerns, on our next slide, concerns innovation competition at the product level. So here, we're looking at the overlaps between the parties' ongoing pipeline products. So here, we are only discussing pipeline products, no marketed products. Of course, as hinted again by the previous panelist, there's a lot of uncertainty in this analysis because, of course, these products have not come into the market. We don't know when they will come into the market, and although we have very good methods of obtaining a big chunk of data, there's still some uncertainty as to the probability of success. Now here, we assess pipeline products, including early-stage pipelines. So in one case of 2019, the acquisition of Seagen by BMS, we assessed the overlap involving a drug in preclinical stage, so even before phase 1, with a phase 3 pipeline held by BMS. At this level of the analysis, what we're specifically looking at is, could the merger change the incentive of the combined entity to invest in parallel R&D? And of course, is there a risk that one of the two pipeline products could be either discontinued, reoriented, or would be coming into the market in a delayed way? As mentioned before, when we are in this scenario, the elements we look at are the probability of success of the pipeline product and the type to market. And in order to get these elements, normally, of course, we tend to send requests for information to the competitors of the parties. We tend to conduct interviews with medical doctors and patient associations. And of course, we tend to request internal documents by the parties in order to better understand the business rationale behind each pipeline. Now, as you can probably understand, the layers between the layer 2 and layer 3 many times overlap. This risk of discontinuation is relevant both for advanced late-stage pipelines and also earlier stage pipeline products. Now, moving on to the fourth layer. As mentioned before, this four-layer analysis was firstly introduced in 2017 in the acquisition of in the Dow DuPont acquisition in the agrochemical sector, and under this theory of harm, what we look at is that the capability of the companies to innovate in certain innovation spaces, in certain therapeutic spaces. For example, in a recent case of 2020, in the field of animal health, we looked at the innovation space of animal health and parasiticides. And what we ask ourselves here is whether the transaction could lead in the elimination of an important innovator, and whether there is a risk of a structural reduction of the overall level of innovation in certain therapeutic spaces. So when we are in this scenario, what we look at is, in each innovation space, are the companies able to innovate? So what we look at is at the emerging parties lines of research, and this is actually quite broad. What we look at is the scientists, the patents, the assets, the equipment, the know-how, and all the other resources that are dedicated to specific therapeutic and discovery target. We also look at early stage and advanced stage pipeline products. What is particular about this expansive approach on innovation competition is that we don't only look, as we normally do with mergers, at the capabilities of the merging parties. What we really try to understand are what are the innovation capabilities of the entire industry. Now, it's true that we have used this approach in the pharma industry, but we have never raised concerns in relation to a pharma merger on the basis of that approach. The reason being that this is an approach that was first introduced in mergers in the agrochemical industry, which is an industry that is very R&D intensive and very concentrated. On the other hand, what we see in pharma is a very fragmented R&D with a multitude of players and many new players entering the market, not only big pharmaceutical companies, but also universities and biotechs. So, overall, this is our four-layer analytical framework, which, as you can see, it's quite comprehensive, and it has the goal of being able to capture all potential effects of such mergers, including the innovation effects. As mentioned before by the previous panelists, the way we approach these issues is by remedies. And although, of course, we have at our disposal both behavioral remedies such as licensing, it is true that in most of our previous cases we have opted for a structural remedy, a divestment remedy, because we have considered that it is the one that can most appropriately resolve the issue, and of course it also is an easier remedy to monitor because it does not require a constant monitoring of the behavior of the companies, that they actually abide by the licensing terms. Now, all this framework concerns mainly horizontal mergers, and of course innovation competition is more important when we look at horizontal mergers. However, we have also assessed innovation competition in pharma mergers when it comes to vertical mergers. So actually in 2022, we prohibited the acquisition of Grail by Illumina. This is the first prohibition decision of the European Commission that is based exclusively on vertical concerns. So now, in this case, we had upstream Illumina, which is an American pharmaceutical company that supplies what is called the short-read next-generation genomic sequencing system. So this is a system that actually analyzes the human DNA, the human genome. And downstream, we had Grail, another American company, a startup company that uses this NGS system and other data in order to develop a blood-based multi-cancer early detection test. So this product is a blood test that can detect up to 50 different types of cancer in asymptomatic patients. What we found here is that Illumina post-transaction would have the ability and incentive to engage in input foreclosure by essentially cutting access to to its NGS technology to great rivals. So they could either refuse to supply or supply in less favorable terms and disadvantage Grail's rivals. Now, as you can see, there's a very good portfolio of cases in the pharmaceutical sector, both on horizontal and vertical concerns by the European Commission. As you can, I guess, also note yourselves, most of these transactions are cross-border transactions. And in such cases, what is very important for us is to cooperate with the other competition authorities that are reviewing the transactions. Of course, we cannot always ensure that we will have an aligned result, but on the basis of waivers by the parties, we are able to exchange views and very detailed views about the case and actually cross-fertilize between our enforcement efforts, which has proven very, very efficient for all authorities in the past. And as I think I have made use of most of my time, I would like to thank you and I would welcome any questions.
Thank you. Let's thank Vasiliki for sharing with us the European experience, a well-structured approach. She mentioned about the 4-layer analysis in competition assessment, depending on the stage of product development, and including as well some cases under each layer. Also the remedies, behavioral and structural remedies that were done in those cases. Now, I understand we've run out of time, but with the indulgence of our organizers, I think we owe it to the guests to entertain a few questions. And also with the indulgence of our very, very good presenters here, speakers, can we have a few questions? Do we have questions on Slido?
Which we do. We want to say thank you for sending your questions, for logging in via the QR code. This is exactly what we'll be doing this afternoon as well. Send in your questions via Slido. Here we go. Here's the first one, moderator.
Okay. The first question is from a person called Anonymous. Assuming no duty to deal apart from the national health, I assume, security, what is role of competition law in refusal to license apart from essential facilities and merger remedies? Anyone from our presenters?
Role of competition law in refusals.
Can you put that on again, please?
Competition law in refusals to license apart from essential facilities and merger remedies. Who'd like to take this? Yusek?
Yeah, I think this is going into the realm of another topic later this afternoon on abuse of dominance. So, as we said, mergers are, well, it's demand-driven, of course. If there's no transaction, you can't really review a transaction, right? But if there are any potential anti-competitive practices that you've seen in the market, then that will be under Section 15 of the Philippine Competition Act. And I believe the Director for Competition Enforcement is also here. So if you have any tips, you can whisper in his ear.
Thanks for pointing that out, Yusek.
Joey,
Commissioner.
please.
I don't know whether this is in that context, but let me talk about compulsory licensing in the context of international intellectual property law, because this is a topic that has always been there. And there's been a lot of questions why we have not resorted to compulsory licensing. It's very simple, 2 reasons. Number one, it's very political, okay? Because you have to get the compulsory license, and then when the big countries now start doing unilateral trade sanctions, the threat of unilateral trade sanctions, I don't think that our governments will be able to really stand up. I'm sorry, to really stand up against such a threat. I mean, this happened in Thailand, this happened in South Africa way back in the 2000s, early 2000s. The other point, the other reason, and the more practical reason, let me ground you, is if you get the compulsory license, you know, you have to have a source of your generic product. Now, if globally, the API, the source of your product is still patented, you get the compulsory license from the originator, but where will you get the product? This was unlike during the time when India was there, you know, that can supply you patented products in your country. But now, it doesn't make sense. So what is the more viable option? Do a voluntary licensing and use the threat of compulsory license as a threat, you know, but generally, it will not happen.
Thank you, Joey. There's also another aspect of that. The government can actually exploit the patented invention akin to compulsory licensing. Thank you. Now, let's get one more question from the list of questions sent. If your questions that you sent were not picked, there's lunch. We can discuss that over lunch, you know, so that not everybody will be held up for lunch. So, should I go 2, 3, or 4?
Take your pick.
Three.
Okay,
Okay, let's go for 3. How should the ASEAN competition authorities work together on reviewing pharmaceutical mergers since we are price takers? Wow. That's very complicated.
I will ground you again, okay? The problem is if you read a lot of this US and European competition books, you know, then you get this thought bubble that this can be done. No. ASEAN will have to develop its own competition policies because the situation, the environment is totally different. And each country has, particularly with respect to pharmaceuticals, each country has different healthcare systems. You know, so pharmaceutical mergers, it depends, you know. If it's a merger of one national company again, vis-a-vis the others, then that's something that you can really work on. But I hate to say this, but if it's a global merger, you know, the sales, ASEAN sales in pharmaceutical as a percentage of the total global sales is very small. That's why we're lumped together with the rest of the world. You know? So the major countries, the major regions are North America, Canada and US, Europe, and of course UK, European Union and UK, and the third one is Japan. China is a different matter, India is a different matter, so ASEAN is lumped together with the rest of the world, together with Africa. You know? So let's stay grounded. What influence can you really do in terms of global mergers of global companies? I really don't know. Thank you.
That's a very practical answer to that question. Global merger, and then you enforce it in the Philippines. I don't know. I don't have an answer to that. Basilki, would you want to say something?
Yes, thank you. I mean, obviously, I appreciate the comment by Mr. Chava. It's true that at the level of the European Commission, we have more years of experience in dealing with merger control and specifically merger control in the pharmaceutical sector. But obviously, when we are dealing with global transactions, there are still challenges. Obviously, when we look at marketed products, for example, the healthcare systems are very different. Even within the EU, in the different EU member states, the healthcare systems and the regulatory regimes are different. However, I have to say that when we look more at the pipeline and innovation level, which takes place at the global level, their cooperation with other authorities, although they do have different regimes and probably different legal mentality, has proven very, very fruitful.
There is one thing that can be done at an ASEAN level, and should be a partner of any competition commission. And these are the consumer organizations. If there can be real, honest-to-goodness, science-based, technical-based consumer organizations in ASEAN, and that can be developed as an ASEAN, then that's a partner of the Competition Commission. I'm sorry to say, but as competition commissions, you will always be subject to political pressure. And you will need a countervailing institution or organization in order to resist some of the pressures that you will be handling. Thank you.
And just to add, so we've had a lot of regional transactions that affects the ASEAN member states. And I think we have emphasized this in various ASEAN meetings in the past. But cooperation among the ASEAN members is really key, that information sharing is number one. And so I was talking with Iskandar about this, that English translation as a start for rules and regulations and laws and cases is a very good start for all of us. And that will improve the information sharing later on. And then we can work together when you have timely information for certain global or regional transactions that affect all of us on how we can deal with that. I would like to flag that, for example, for the Grab-Uber merger, it was actually, there was actually regional cooperation that occurred in that transaction. Thank you.
One more. Sorry, just one more. Pharmaceutical industry is a very opaque industry. You wouldn't know what's going on there or the structure unless you come from there. But, and that's the reason why even the Minister of Health here, the Department of Health, doesn't know the cost structure of pharma. But Thailand does, because they have the GPO. You know. So in an exchange of information between them and your competition commission here, you will get a lot of data that you will otherwise not get here in the Philippines. Thank you.
So thank you. So one word for all the answers: cooperation, collaboration, cooperation within the region, within the global structure, and also Joey mentioned cooperation with or collaboration with a real honest-to-goodness consumer group. That ends our session. Thank you very much for your patience.
Thank you. A round of applause for our Commissioner Negre for moderating the first panel. Attorney Chave, Undersecretary Uy, Mr. Tobman, and Ms. Dolka, thank you for your inputs as well and presentations. And with that, first session alone, we're already quite on fire. Let's all have a good lunch. Prepare for the afternoon. Not just the launch, but 2 more sessions. For now, please enjoy lunch, everybody. Thank you. Good afternoon, everybody. Please do settle down. The program will resume shortly. Once again, we invite all of our guests to please settle down. The program will begin shortly. Good afternoon, delegates. Good afternoon, everyone. This is again the 10th ACC. Did you have a good lunch? Give me a thumbs up if you had a good lunch. Fantastic. And I hope you took the opportunity to talk to each other, continue the discussion off stage, as Commissioner Negre actually suggested. Even though we don't get to answer all the questions here, we continue it in your tables and in the audience area. So moving right along, before we move to the second session, we have the launching of the peer review report on Malaysia's advocacy programs. And we have our moderator for this, Mr. Thang Van Luong, the head of Competition, Consumer Protection, and IPR Division of the ASEAN Secretariat. Let's give him a round of applause, please. I'll be asking him to come on stage with our panelist, Chief Executive Officer of the Malaysia Competition Commission, Mr. Iskandar Ismail. And online, we have the Head of PR and Cooperation Bureau at the Indonesia Competition Commission, Mr. Deswin Noor. Shall we flash Mr. Deswin Noor? So we have a photo opportunity first with our gentleman. There he is, Sir Deswin. Please smile. You're on camera. Keep smiling, Sir Deswin. Thank you very much. Mr. Thang Van Luong, please take it away.
Very good afternoon, ladies and gentlemen. Actually, I find my task very hard after this nice lunch together, but I'm trying my best. My name is Thang Luong. I am now Assistant Director at the ASEAN Secretariat. I'm overseeing the competition, consumer protections, and also IPR. It's really my great honor to be the moderator for today's sections, which is going to touch on the launch of the peer review report of the Malaysia Advocacy Program that will be delivered by Mr. Iskandar Ismail, CEO of the Malaysia Competition Commission, MyCC. Our section will be seconded by the second panelist, Mr. Deswin Noor, Director of the Public Relations and Cooperation Bureau of Indonesia Competition Commission, KPPU, as the ASEAN Member State Peer Reviewer. As we are well informed, under the ASEAN Competition Action Plan 2025, all ASEAN Member States agree on several strategic measures to further cooperation to aim at achieving key goals, which are strengthening the competition policy institutions, meaning laws and regulation and policy, and strengthening the capacity for all ASEAN member states, competition authorities, and fostering awareness and building the culture of fair competition in the whole region, and move towards the greater harmonization and convergence among competition policy and laws within the nation regions. To achieve that goals, ASEAN member states agree to conduct at least 2 peer reviews of the national competition laws by 2025. The peer reviews aim to review their existing competition regimes in light of their enforcement experiences, changing market dynamics, and in line with the international best practices. The review is built on the foundation of voluntary flexibilities and inclusivity. So we are happy to inform you that Malaysia and Thailand are 2 volunteers among ASEAN family to conduct the peer reviews with the support from ASEAN development partners and under the guidance of ASEAN expert groups on competition, ADC, and with also the coordination by ASEAN Secretariat. So, Malaysia version is focusing on the power of advocacy Why Thailand version is more will be focusing much on the e-commerce side. So before we delve into the first presentation, I wish to reveal some secret information on Mr. Iskandar, our first speaker today. Actually, he's enjoying his education both at home in the International Islamic University of Malaysia, and also they follow his master in comparative and international law at George Washington University Law School. And actually, I think that his proud profile goes beyond his education, actually. When working for the Central Bank of Malaysia as a member of the pioneer prosecuting team for financial crime cases. And notably, he's landing himself with 8 years working for the, as the assistant trial attorney with the United Nations for the International Crime Tribunal for Rwanda in Tanzania, prosecuting genocide and serious violation of international human rights laws. So before shouldering his responsibilities as the MyCC CEO, he held 5 years as being director of the Investigation and Enforcement Division at MyCC. So now floor is yours, Ms. Iskandar.
Assalamualaikum warahmatullahi wabarakatuh. And a very good afternoon to everybody. I hope you had a good lunch. I had a good lunch. Thank you so much, PCC. You see, before I dwell into, deep further into the peer review report on our advocacy programs, I just want to share you some experience that I went through. In 2015, I went to Geneva for UNCTAD conference meeting, for meeting on competition. I still remember that time, at that point of time, Romania was the subject of a peer review by UNCTAD panels. From that experience, I swore to myself, I said, Malaysia will never be peer reviewed by anyone. You see, it was so, I found it so difficult to answer. If I were Romania at that point of time, I don't think so I can answer all the questions, because somehow peer review will expose everything, But couple years later, AEGC, they came out with this idea. They had this funding to do this peer review. So everybody was asked, Malaysia, Singapore, Philippines, everybody was asked, who wants to be peer reviewed? Nobody raised their hand. So at last, we relented and then we said, okay, but one condition, only on certain area. So that's why we gave on our advocacy programs only, to be peer reviewed by ASEAN. So I would like to say thanks to AEGC and the sponsor for this peer review report on Malaysia's advocacy programs. Thank you so much for giving us the opportunity. Okay, it started a couple of years ago. So the highlights of the peer review, somehow they presented to us, there are 4 things. So through our advocacy program, they saw that increased awareness and understanding of what is MyCC doing in Malaysia with regards to the development of competition law. And then they saw that our promotion of competition was quite effective. And then, of course, there will be areas for improvement for us. They identify areas where MyCC can further enhance its advocacy activities, including refining communication strategies and targeting specific stakeholder groups. And then, of course, they said we need collaboration and knowledge sharing. They emphasize the importance of collaboration and knowledge sharing with other competition authorities. We are doing it now. We are close to PCC. Yeah, PCC, have taught us a lot on merger laws, and JFTC, ACCC, yeah, and then we have our friends in Hong Kong Competition Commission. We have CCCS Singapore. We have CMA. Yeah, so we are doing it. We hope that next year we will collaborate more with US DOJ and FTC. Yeah. So there are 8 key recommendations to our from our peer review. One is to strategy to expand impact. Okay, so they said you have to develop unique communication and engagement strategies. What does it mean by unique? Don't try to do the same thing over and over again, expecting different results. That's what I gather from there. So we are trying our best right now to do different things. I will explain to you later, yeah? And then we have to monitor and evaluate. So we carried out awareness studies from time to time. Right now we are carrying out these awareness studies with our stakeholders. So we hope to get the results by end of this year. And then the third one, enhance resources. Thank God, this year, recently our Prime Minister have announced the new budget for 2024. We got an increase of almost 100% of our budget. Yeah, so now is the opportunity for MyCC to expand itself. Yeah, and then focus content. The content, in other words, they are saying it must be focused. Basically, all this while we have targeted 5 groups. Yeah, the first one is the practitioners, be it lawyers or economists, although they can't sit together and they can't agree always. Yeah, and then we targeting also the business people, the entrepreneurs, the government sectors, the students and lecturers, and last but not least, the media. Yeah. So, to me, the most important 2 groups are the medias and the government sectors. You must get the support from your peers in the government sectors. This is the hardest part. Yeah. It took years for us to convince our Ministry of Finance to amend their circular on procurement. Yeah. I think we have given them more than 10 advocacy programs. We have gone to them, presented our ideas and whatnot. And lastly, they are now keen to work with us more. And media. Media is the other challenging part. Yeah. Because they always equate cartel with monopoly. Monopoly is a cartel, cartel is a monopoly. Yeah, it's like speaking to them, going through their left ears and it will go out through their right ears. Yeah. So you have to ensure that they understand you. Yeah. So that's what we're doing. We are doing a lot of things with media. And the 5th one, visibility and deterrence. We are intensifying our enforcement actions. You will see by end of this year, we will issue another 2 decisions. It will be announced soon. And then social media. Social media is fun, but you have to be careful. Yeah. So I will elaborate on this after this. And combined platforms. We are now on the verge of launching our e-learning 2.0. It's so tiring to go, all over Malaysia and teach people about competition law. Or at least share your knowledge or experience on competition law. Yeah. So e-learning 2.0, I think is the best alternative platform for you to teach the public especially. And then last but not least, impact assessment on market reviews. Last time, honestly, I don't believe in market reviews. Because coming from a prosecutorial background, we believe charging people in court is the most effective way. Yeah, 13 years I was in prosecution field. But after a while, I saw market review is one of the best tools for advocacy. Trust me. Next year, we will be carrying out another market review on digital economy. Yeah? And please be patient. If you list 100 recommendations, don't expect your government to follow hundreds of them, all of them. They will take their own sweet time. Okay? They may implement this year or they may implement it the next 5 years. It happened to us. Yeah? So next one, okay. When they did the market review, they took into account the activities up to 2021. But for now, we have carried out issued 90 policy advice. 5 more are coming before the end of the year. Economic advice, we gave them also, to the government especially, and then we carried out 350 advocacy programs. If you divide, we were established in 2011, now it's 2023, 12 years, you divide by 12 years is about 30 advocacy physical program. It's so tiring, yeah, but we had to do it. We had to go all over Malaysia and then tell them again and again the benefits of competition law. We are not complaining, we are having fun, but it's just that there should be another way on how to advocate on the importance of competition law. And we issued 7 guidelines. Yeah? But to me, among these 4, policy advice is one of the best tools also. You see, policy advice is just an advice. It's up to them whether they want to listen to you or not. Yeah? But it's good that you are breathing on their neck. They will feel irritated at first. They will feel annoyed by you, by your advice. But later, I'm very sure they will listen to you. So keep on issuing policy advice, even though it's not solicited. Yeah? So, there are things that we have done, that we have improved in how we try to portray MyCC and competition law in Malaysia. It's very important that you have faces of competition in Malaysia. So in 2019 or 2018, we introduced 2 new faces for competition in Malaysia. Malaysia is a small country. Yeah? So we can't afford to have a lot of people explaining competition law in Malaysia. So we chose 2 faces. One of the faces is yours truly. Yeah? And then we changed our logo to make it fresh. Last time MyCC, you see the word MyCC is very small. So now it's very big. As simple as that, it will make people notice about us. Yeah? It shows that we grow also. And then, talking about digital platform or social media. You have Facebook, you have Instagram, you have LinkedIn, you have TikTok. I know some of you wouldn't want to be involved in TikTok, but we did. Yeah, although we know that Facebook has almost 3 billion followers, Instagram around 2 billion, but we chose LinkedIn and TikTok. You know why? Because they are more real. Facebook is old school. I'm sorry to say that. Yeah? There are too many scammers there. Yeah? Instagram. I thought LinkedIn is better. Yeah? We put aside Twitter. We prefer Tesla better. Yeah, because Twitter now is owned by, the guy who did all these electric cars. Yeah, and then YouTube, it takes a lot of resources to maintain YouTube channels. So we decided to focus on LinkedIn and TikTok. So please, you are welcome to visit our TikTok channels. Yeah, we don't have much followers. Yeah, it's a start. Yeah. So the way forward, okay, taking into account all the recommendation, all the findings of the peer reviews, okay, so we decided to carry out public announcement on our decision. We will hold press conference. We will explain. In fact, we will call all the main media to come a day before the announcement of the decision and explain to them in details, and we embargo them. Yeah, so the next day after 12 o'clock, then only you can release. So at 12:01, the news will be out. If you don't do that, it will be out during the night. During the night, people will be tired already. Yeah? Some of us do not watch TV anymore. Yeah? And then we have to be rapport with media and journalists. We issue press statements on current issues. Recently, we issued a press statement criticizing the lawyers because they have increased their conveyancing fee, and it's a fixed conveyancing fee. They have increased their fees for the third time in less than 10 years. So we criticized them. And then, of course, they retaliated, as usual. Yeah? But as long as you have said you have put your stand out there, I think that is good enough. And then we have initiated a competition impact assessment in Malaysia. Every time you want to introduce or amend new laws, you have to go through this process, what we call regulatory impact assessment. But in that assessment, doesn't have any competition aspect of it. So what we did, we worked with the Malaysian Productivity Center in Malaysia. We introduced this competition impact assessment. And we ink MOUs with universities and regulators. We carry out free classroom. We held open day for students. And then we created this best student award for competition law subjects so that the best student will work for us eventually. Yeah. And then we try to create consistent syllabus for all universities who have introduced competition law. We do not have enough economists or lawyers that focus on competition law. So it's better that we have a consistent syllabus so that everybody talks the same thing. And then impact assessment of our enforcement activities. We recently carry out impact assessment. We have the report. We're going to launch it soon. And then we have special committee meeting on competition. We chair the meeting. And then we ask around 9 regulators to join us, among them Central Bank, Intellectual Property Office, Companies Commission, and then Energy Commission and other regulators to sit down with us every year, at least twice a year, to talk about competition issues. Yeah? And then we hire experts also. Yeah? It's very important that you hire experts, be it foreign or domestics. Yeah? Not everybody, in my CC, not all are good in competition. They are still learning. So we have to learn from the best. Yeah? And then collaboration with other competition authorities, I think I have said that. But we are thinking of having MOU with certain competition authorities out there. And then we have new projects. We're going to amend our laws. We are going to carry out market review on digital economy. And then we're going to have e-learning 2.0 and 3.0. We are working two at the same time. 3.0 will be on merger only because we're going to introduce merger soon. And then we are going to expand ourselves. And last but not least, political will. I think PCC has no problem with political will. Your government fully support, they made it as a national policy. Correct me if I'm wrong. Yeah? So, it's not a national policy in Malaysia. So we had to visit some of them, some of the politicians. We in fact made a courtesy call to the Prime Minister and other key ministers. And we went to visit several ministries also. Yeah, we invited ourselves to their office sometimes. Yeah, we had to. After all, we are government officers also. Yeah. So, those are the things that we have done so far. Thank you so much again, ASEAN, for making this reality. We owe it a lot to you. I hope that, I think after this, the peer review will be on PCC, right? No? Oh, okay, I got it wrong. I got the country wrong. Yeah? Yeah, you're going to launch it, yeah? So, sorry. Okay. Anyhow, I hope that you can, join us. Yeah? It's going to be fun. Yeah? It's going to be fun. People will go through your files and whatnot, and then they will criticize you subtly. I think you just have to open up and embrace it. Yeah? Okay, that's all. Thank you so much, and have fun.
I thank you very much, Mr. Iskandar, for very confident presentations. Actually, we consider Malaysia and Thailand are two musketeers who are brave enough and pioneer in doing this two peer review for another ASEAN member state to follow. As a rule of the game, the peer review will be reviewed by another AMS. In this case, it is reviewed by Indonesian competition authorities. So to follow, I would like to open the floor to another panelist who are having actually more than 2 decades devoting himself for the Indonesia Competition Commission, KPPU, with profound education in both graduates and postgraduates on financial analysis and financial management. He has been able to perform well in various areas, such as international negotiations, competition policy analysis, case investigation, merger review. For his nation, he used to be a lead negotiator in many FTAs, director of merger directorate before being director of public relations and cooperation. At the same time, he is editor-in-chief of the OLI Competition Policy and Law, YONO, in Indonesia. In Bahasa, Jonan Pesainggan Uhas Usaha. Sorry if I mistaken in pronouncing. For ASEAN, he used to be the chairman of ASEAN Expert Group on Competition, ACC, and now actually he is the chairman for ASEAN and China FTA working group on competition and consumer protections. So actually his name is Mr. Deswin Noor. So I would like to open the floor for you. Pak Deswin, please.
Thank you, Kang. So, hello everyone. Magandang hapon. Good afternoon. It is always a pleasure for me to speak in front of colleagues in ASEAN. So my sincere apology for not being there in person. So today I will talk about the ASEAN way of peer review. Peer review in competition law and policy is considered a new practice for ASEAN. Several international organizations have implemented them before, like what Sheikh Iskandar mentioned, UNCTAD. There are also several international organizations that do a peer review, so it can be a good reference for ASEAN. However, I must say that the ASEAN way of peer review is different. So I will tell you why. The peer review is one of the activities in the ASEAN Economic Community Blueprint 2025 under strategic goal for the establishment of effective competition regime to strengthen the capacity of competition authorities and move towards greater harmonization of competition policy and law in ASEAN. Can organizer move to slide, please? So simply to say that the main principle for the ASEAN peer review is ASEAN helping other ASEAN. So the role of ASEAN member states in the peer review is very significant. So there are four, can you move the slide before this? So there are four parties involved in the peer review. The review authority, in this case, Malaysia Competition Commission, other competition authorities, in this case, Competition Authority of Indonesia and also Singapore, the consultant, in this case, academics from Singapore, Malaysia, and also Japan, and the ASEAN secretariat. So the last three parties are considered to be the peer review team, the one that conducts the peer review. So at least there are three main features of ASEAN peer review. First, which are voluntary. The peer review is based voluntary. And then flexibility. The review authority has the flexibility to define which area to be reviewed. So in this case, for Malaysia is competition advocacy. And the last feature is inclusivity, where all ASEAN competition authority can participate in the peer review process. So these are the three features that differentiate ASEAN peer review compared with other types of peer review. The process is quite long, at least 6 months minimum. So it starts from defining the focus of the peer review and nomination of the peer review team. Then the review authority will conduct the ASEAN self-assessment toolkit on competition enforcement advocacy and send the result to the consultant to understand more about the review authority. Then the consultant and the review authority will discuss the review plan and also methodology and seek the input from us, ASEAN peer review team. So the consultant will conduct this research, necessary survey, or do an interview, a stakeholder interview. Following that, they will prepare the report and then get comment from the peer review team, present the report at the AGC plenary. So this is where the AGC will review the report, the peer review report. From the plenary, the consultant will finalize the report based on the input provided by ASEAN member states. So this is where all member states can provide some comment, input, put some stress on the report, and then provide it to the consultant so that it can be adjusted in the peer review report. So from what we have implemented, we recognize that several outstanding challenges for the ASEAN peer review. Can you move the slide, please? The first challenge for ASEAN peer review is the incentive. Incentive for the review authority need to be prepared so that more competition authorities want to be reviewed voluntarily. Like Jay Iskandar explained, at first there's no one to be able to be want to be reviewed, but my CC come out and say that they are fine to be reviewed at least in a specific area. So this is one thing that ASEAN peer review need to be consider, how to shape an incentive for member states to be voluntary being reviewed. And then There are also limited number of regional consultant and dialogue partner support to implement the peer review. So this will talk about the continuity of this peer review program. So if there is no good support to this program, so we don't know whether the peer review will take place in the future. So this will create a certain issue. And then the absence of standardized questionnaire methodology may lead to inconsistency. Yes, we do have a guidance document. We do have a guidance document with a sample questionnaire and methodology. And it may need development in some parts because the early focus of this guidance was on the management part and yet the substance. So I think in the future, we need to start thinking about revising the guidance document. As for Indonesia or KPP itself, there are benefits to being one of the peer review teams. Even though we have more than 23 years of experience, we can also learn from the review authority, from their experience, especially what to avoid and how to anticipate unwanted outcomes. Because the most important lesson is to learn from our failures so that we can create our own success. So lesson from other ASEAN member states is more acceptable since we share common cultures and also common values. The lesson from ICC, from the report that we acknowledged, was the operationalization of Special Committee on Competitions, and also the importance of collaborative actions between market studies, enforcement, and policy advocacy. These are important lessons to KPPU. So these are several areas that we also would like to know, to learn more from ICC, how the practice and how the result, how is the outcome from this two interesting part. So this process also improved KPPU's expertise on how to conduct a peer review and can set an example for any other area. But what important was, it will increase the need for KPPU to develop a program to assist other ASEAN competition authorities and improve KPPU's internal expertise to implement such program. We noted that Malaysia, Singapore own a research grant program to the academics. I just knew that from the report, Malaysia have the program for grant program for the academics. So this is something that Indonesia will also need to be considered in the future. Indonesia have a specific aids for developing countries. So this is something that we also will need to think about, how we can make best use of, how we will create a grant program for the academics so that we can build knowledge for competition, also build some expertise, regional expertise for competition policy. So these are several benefits that we can share in this afternoon. So therefore, to conclude, we would like to congratulate and thanks MyCC for their bravery in being the first peer review country. Thank you so much.
Show my, my capacity in terms of moderating this section within 30 minutes. But may I abuse my humble position a bit to accommodate one question? It might comes up from Slido. I don't know whether Slido can have the long list of questions regarding the sections or. Wow, again, Mr. Anonymous. Mr. Anonymous, so I have to pick one, right? So it really depends on Mr. You want to pick which one, or Yeah, I think the number 2. Yeah, Iskandar, please.
Yeah. What information do you share with to the public regarding your ongoing investigation? One thing, I think the public understands, and they are quite, public, they have high expectation. There are a group of impatient people. Yeah. And for your information, MyCC is a quasi-judicial body. We investigate, we decide, we enforce the decision. So everything is under one roof. So it takes time for us to come out with the decisions. So how do we share our information on the ongoing investigation? We don't announce once we start an investigation, but we announce when only 2 times. One is on the proposed decision, the second one is on the final decision. That's all. We have to make it clear to them that we are not here to embarrass any people. We are doing it, for the sake of the law. So, but we sometimes we have a session, few sessions on to explain on the past decision, on the details of our some of our previous decisions. So hopefully they will understand us. That's why the media is very important.
So only proposed decision
And final
then
decision.
Final decision.
Yeah, that's all.
Okay. Thank you.
Yeah, thank you. I think thanks for your answers, and which close actually our section to give the floor to another sections. Before Ms. Askana and myself leave the floor, I would like to ask for the big hands from the floor. For
A round of applause, please.
Thank you.
Thank you very much again. That's our moderator, Mr. Tang Van Luong, Mr. Iskandar Ismail, and Mr. Deswin Noor. Thank you very, very much again. The peer review report on Malaysia's advocacy programs. Thank you very much for sharing. Moving right along to our second session for day 1. Again, the title is Combating Anti-Competitive Practices and Licensing in ASEAN Pharma Markets. We are still in the pharmaceutical industry. So for this, an overview. IP protection allows innovators to reap benefits from ingenuity. In the pharma sector, patents are common to incentivize the development of new drugs and guarantee returns from investments in research and development. Now, to facilitate technology transfer and improve market access, IP licensing schemes are allowed to provide a way for external parties to make use of the innovator's products or processes. Likewise, after the expiration of a patent, other firms are allowed to produce generic counterparts to expand patient access to cheaper alternatives. However, innovator firms may be incentivized to foreclose their competitors through exclusionary conducts and agreements to preserve their market dominance. For instance, they may engage in evergreening or pay-for-delay deals that undermine generics competition by delaying the entry of competitors. So this second session this afternoon, ladies and gentlemen, will examine best practices in IP licensing and possibly regulatory measures that ASEAN member states can put up to prevent abuses of dominance and also to promote competition in various levels of the pharma value chain. It also aims to discuss how antitrust authorities can work with IP regulators to detect and prosecute anti-competitive agreements and conduct in the pharma sector and ensure the robustness of generics competition. Let's get into it. Moderating this session is Mr. Manayos Vardanabuti. We have Deputy Secretary General of the Trade Competition and Commission of Thailand. Joining him are our panelists. Again, from the Vietnam Competition Commission, Deputy Chairman Ngo Duc Minh, and the Senior Attorney of the Bureau of Competition of the U.S. Federal Trade Commission, Mr. Marcus Mayer. Not quite done with my lineup. We have also of the Bureau of Patents of the Intellectual Property of the Philippines, Attorney Fatima Mamangon is joining them. And from Jakarta, online, We also have a virtual panelist, Commissioner Chandra Setiawan of the Indonesia Competition Commission. May I ask someone before you take your seats, may we have a group photo? Everyone stand in front. We have this group photo tradition before the actual session. Please do smile. Mr. Commissioner Setiawan, you are included in the photo. Smile, please. Thank you. Thank you very much. You may now take your seats as I turn over the microphone to Mr. Manayos Vardanabuti. Good afternoon.
Hello. Hello, good afternoon. Good afternoon, everybody. My name is Manayos Vardanabuti from Thailand. Today, the topic is very interesting. The global intellectual property system is currently facing challenges related to the perpetual patenting, known as evergreening patents. This involves making minor modification to patent detail by original right holding companies or engaging in pay-for-delay agreements, where pharmaceutical companies are paid to delay or halt the release of generic competitors. These practices transform the patent system into a tool that hinder research and distribution, becoming a significant concern in many countries due to potential hindrance to both market competition and innovation. The focus of today's discussion revolves around the growth of the pharmaceutical market in the ASEAN region, attracting foreign investment. Regulatory bodies in both competition and intellectual property are tasked with finding solutions to these issues, aiming to make the patent system a mechanism that promotes competition, lower drug price, and enhance consumer access. The esteemed panelists for today include Mr. Chandra Setiawan, the Commissioner of the Indonesian Competition Commission, Mr. Ngao Dak Min, Deputy Chairman of the Vietnam Competition and Consumer Authorities, Mr. Marcus Mayer, the Senior Attorney from the Bureau of Competition and the US FTC, and the last, Ms. Fatima Mamagon. She's the Intellectual Property Rights from the Intellectual Property Office of the Philippines. We will begin with Mr. Marcus, who will present the challenge related to the pharmaceutical patent and the enforcement of US FTC law. After that, the following will be invite Mr. Ngao Dak Min and Mr. Chandra from VCC and ICC to provide us an overview of the pharmaceutical industry in Vietnam and Indonesia. And the last, Ms. Fatima, will then share insight on pharmaceutical patent in Philippines. Okay, please, Mr. Marcus.
All right, well, thank you very much. And the challenge I'm facing is I'm going to tell you about 25 years of my work together with 35 colleagues at the FTC, and I'm going to do that in 15 minutes because we've been enforcing competition law in the pharmaceutical space for the last 25 years. In my office, we conduct investigations, and if the case goes to trial, we also try the case in courts. So I personally have tried cases all across America in district courts, courts of appeals, and you're going to hear about one case we got all the way up to the US Supreme Court. So let me just move it quickly here now. Quick overview, I'm going to set the stage by talking about something that's known in the pharmaceutical industry as life cycle management. I'm going to talk a little bit about what I call the three systems, and some of that's already been introduced a little bit earlier, though they didn't use this terminology when Mr. I think it was Ochoa and also the woman from the EU, Ms. Dilka. I'm going to talk about the three systems, the important context that you have to understand in order to successfully bring cases in the pharmaceutical industry for antitrust violations. I'm going to talk about two types of cases. We've done many different types of cases, but I'm going to talk about two types that were highlighted in the introduction, so-called pay for delay and evergreening. And the most important thing I'm going to do is I'm going to point you to far more information that you can find on the FTC's internet, because I can't possibly really talk about 25 years in 15 minutes. Life cycle management, also sometimes called evergreening. You've heard the term evergreening, it was used earlier today. They're actions that brand and generic companies take to protect an existing product from competition. Every pharmaceutical company, brand and generic, but especially the branded companies, have some kind of a life cycle management team inside the company. This team consists of intellectual property lawyers, regulators, people who have experience with food and drug regulation. It includes scientists, it includes doctors, pharmacists. It's a multidisciplinary team, and their job is, once you have a successful branded product or a successful drug product, you want to keep that success going as long as possible. So you bring together this multidisciplinary team that tries to do everything it can to extend the life of the product as long as possible, because the longer they can sell the product, the more profits they can make. This conduct can be perfectly legal and perfectly legitimate under all of the different systems that I've looked at around the world, but under certain circumstances, they may cross the line. And I'm going to talk about two of those circumstances where the line might be crossed. The three systems that we're talking about are the patent system, the pharmaceutical regulatory system, and the medical care system. And again, you've already heard a bit about that today, that to be an effective competition enforcer in the pharmaceutical space, you have to understand the patent system. You have to understand what a patent is and what rights accrue to a patent. You have to understand the pharmaceutical regulatory system. We want to make sure that drugs are safe and effective. In the United States, we have an organization called the Food and Drug Administration. They consist of doctors and scientists and pharmacists, and their main job is to make sure that if human beings in America take drugs, the drug works and it's safe. You have to understand that regulatory system. You have to learn it. If you don't know it, you have to learn it. And finally, we have the medical care system, which also creates its own set of problems. For most of us, when we think about being a consumer, we think about a person who decides, I want a new car, or I want to buy a new pair of blue jeans or whatever. You pick what you want to buy, you go and buy it, and then you put on the jeans or you drive the car. In the healthcare system, and this is true everywhere in the world, even though medical care systems are different, there's one person who picks, that's the doctor. There's one person who pays, that might be your insurance company or it might be your government. And there's another person who actually swallows the pill. And so that decision that's normally made by one person called the consumer may actually be made by many different people. And that's true everywhere in the world, even though our medical care systems differ greatly. And that creates its own set of issues and problems and potential problems in this area. So let's talk about reverse payment agreements. Wait a minute, what's reverse payment agreement? I thought you said pay for delay. In America, we use the term reverse payment agreement instead of the words pay for delay. We used to use the words pay for delay, but we brought a case all the way to the Supreme Court. They decided to call it reverse payments. We decided we're going to go with them. Here's the scenario. Let's split this room in half. You guys are the branded industry. You all are the generic industry. I'm the I'm the FDA, or I'm sorry, correction. I'm the FTC. I'm the competition enforcer. You're the brand companies. You're the generic companies. Here's the scenario. All of a sudden, you generic companies want to enter the market. You want to bring in your low-cost, cheaper generic version of their branded product, and they sue you for patent infringement. Okay, so we have a lawsuit going on between two sets of private companies, the branded companies and the generic company. And at some point, like most litigation, it's true in America, it's true around the world, you look at each other and you say, why are we spending all this money fighting each other? Why don't we settle our case? And the type of settlement that we're worried about has two terms. It must have both of these conditions to be problematic. Number one, the generics, you all agree you'll stay out of the market. Even though you have final approval from the regulator, even though your product has been approved and you're ready to enter and you can make the product, you choose to stay out for some period of time. And in return, this side of the room, the branded companies pay you money. They pay you something to stay out of the market. The reason we call this a reverse payment agreement, any of you ever done patent litigation? Any familiar with the patent system? In the patent system, the brand companies are the patent holders, and you are the alleged infringers. Why is the patent holder, who has this wonderful patent, paying you to stay out? In most cases, settling patent litigation, the infringer pays a license for a license to the patent holder, not the other way around. This is why it's called a reverse payment case, because it's this curious situation where the brand company that owns the patent is paying the generic company who supposedly infringes the patent to stay out of the market. Now think about this. Brand companies, what's your incentive? Your incentive is to keep the generic out as long as possible. The longer you can keep them out, the more money you make. Generic companies, you don't make any money till you enter. You want to get in as soon as possible. That's your incentive. If all you did in this settlement was agree to split the life of the patent, let's say the patent was 10 more years, you did a 50-50 split, me as the competition authority, I could care less. You have opposing incentives. You want to stay out as long, you want to enter as soon as possible, and whatever you worked out must reflect your best judgment about the merits of the patent litigation. But now all of a sudden, they pay you some money. Are they paying you for that same early entry date, or are they paying you to push you out further? That's what's going on in these cases. We are arguing in these cases that it is not part of your patent rights to pay your competitor not to compete. And here's a quick pie chart model just to show you what it looks like. Before the generic entry, the brand, you make all the sales. You make $1 billion, you make $10 billion, whatever, a year. You got the whole pie all to yourself. Under competition, you would get part of the pie as the brand, generic would get part of the pie, and consumers save money because the generic costs less. And all the reverse payment or pay for delay deal is doing is it's taking away the consumer slice of the pie and dividing it between the brand and the generic. And if you look at the picture, the way we've got it up here, in some instances, you can actually pay the generic more than the generic might have made by entering. They're splitting, they're just taking away the consumer's piece of the pie. And we as the enforcers say, nope, you can't do that. I've highlighted, these are all different reverse payment cases. I started the very first ones in investigations in 1998. In 2000, we brought our first cases. These first couple cases that I have in 2000 and 2001, we didn't even have to go to trial. They gave up. These cases involved brand company literally paying a bag of cash to the generic companies. The other last one I got highlighted is FTC versus activists. This is the one that went all the way to the Supreme Court. Before this activist decision, the courts were saying, it's okay. It's okay for the brand to pay the generic. It's within the scope of their patent rights. And the Supreme Court said, no, it is not within the scope of the rights of your patent to pay your competitor not to compete. All right. Product hopping. Okay, again, where'd that term come from? You said evergreening earlier, you said life cycle management. Well, we call it product hopping when it's an illegal act. And what we're talking about here is you have to understand the regulatory context. And this is, I know it's different in America than around the world, but I've been to enough different places to know that some of these same kinds of things can happen in different countries. The FDA in America has to decide that a generic product really is the same as the brand. And if the FDA decides that the generic is really the same as a brand, then pharmacists all across America are allowed to take your brand prescription and give you the lower priced generic product instead. It creates an automatic market for generics. That's basically what's going on. FDA said, generic, you're the same. Pharmacist says, I'm going to switch you to the lower cost generic. Okay? That's the picture. But what they do, what the life cycle management team and some of these pharmaceutical companies do, is they make some little switch to the brand or product right before the generic companies enter. And these are just some examples. You can switch it from a capsule to a tablet. You can switch it from a tablet to a capsule. You can make it, instead of 70 milligrams, it's only 60 milligrams. You can make it chewable instead of swallowed. Whatever, you start to change the form in different little ways, and it's no longer automatically substitutable. The generic can no longer automatically be substituted by the pharmacist. This is what's going on in product hopping. Some of these switches are perfectly fine. We would all agree that if you have to take a product 3 times a day and they make it a once a day pill, that's a good thing. But what if they just take a small little pill that nobody has any problem swallowing and they make it chewable instead? Well, maybe that's not as worthwhile. This is the tough job we have as enforcers. So our theory of product hopping has to have 4 characteristics. It has to be a minor non-therapeutic change, something that's not actually medically beneficial for you. You have to have actual or constructive removal of the branded product from the market. By constructive, I mean they make the price so high that nobody would even buy the old product anymore. You do this right before the generic is about to enter, and it has to be done by a company with monopoly power. Here are some of the FTC product hopping cases. We've had a number of them going back to 2000. The ones that I've highlighted in 2019 and 2020 was interesting because it was also being prosecuted criminally because these companies had made up false information that they gave to the Food and Drug Administration as part of their product hop. And so we also brought an antitrust case at the same time that there were criminal prosecutions and people from these companies who pled guilty to crimes. All right, I told you, last thing I got to do is just say, hey, look, there's a lot more information available on the FTC's website. This is that document. I'm going to retire in December, so this will be the last time my name is on this document. But this is a 110-page compendium of every case, 110 pages of every case we've ever done in the pharmaceutical industry by different topics, with hyperlinks to much more information about each one. We also have done a number of sector studies and reports, and they're also available. They're discussed in here. Pay for delay, how it costs consumers billions of dollars a year. We have a number of other studies and reports. So if anything I said today was at all interesting to you, and you can't remember what I said, don't worry, just go here, take a look. Thank you.
Thank you, Mr. Marcus. That's very comprehensive explanation about the pharmaceutical market and the best practice from US FTC expert. So now we have to move on, Mr. Ngao Dakming, to give us a presentation on the
Stay in my place. Okay.
the Vietnam.
Okay. Thank you, Mr. Moderators. First of all, I will misuse my time to say thanks to PCC and its chairman, its commissioners for this excellent arrangement for the conference. That was a magnificent conference room. Today I will present to you a very quick and with some information about the pharmaceutical sector in Vietnam. Before 2010, in Vietnam, we have some concern about the monopoly in the pharmaceutical sector, and sometimes we have news about one drugs had the price have been quadrupled and or 5 times, 10 times more than before. For over a years or for 3 months or over a years, and every hospitals cannot afford to buy these drugs and to provide to the patients. And but after 2014, things are changed, and oops, okay. So with the new policy in Vietnam in place, especially the national strategy for developing Vietnam pharmaceutical industries, issued by the prime ministers, things are changed. After these decisions, the National Assembly will promulgate the law on pharmaceutical products and the decrees, and with that, the decree of the government that detailing the articles. And just last month, the Prime Minister issues a national strategy for development of the pharmaceutical industry. Just some information about the pharmaceutical industry in Vietnam. The total market values at 6.4 billion a year, and it will reach $16 billion by 3 years from now. And as you can see that on the production side, you can see that we have a very fragmented market with a lot of players in the field. Vietnam have 51 foreign invested pharmaceutical manufacturing enterprises and a lot of domestic producers of pharmaceuticals products. Being said that, we see that as a competition authority, we see that the pharmaceutical production segment of the markets is very competitive. From the distribution side, we have a lot of special market segments. We have the professional drug distribution business. We have the pharmaceutical distribution foreign companies, and in Vietnam law, as our previous presentators has been said, we need to look at the pharmaceutical sector regulations to see how the structure of the markets work. And in Vietnam, we have a very special regulations to regulate the distribution of drugs that help a lot to offset the monopoly side of the drugs. I will present this later. Some of the trends, we see that the development of the private hospital will support the growth of the pharmaceutical industries. In Vietnam right now, we have many of the chains of the private hospitals that increase the growth of the pharmaceutical industries. We have also a trend that the generic drugs will achieve strong role in the coming years. The prescription drugs are expected to account the biggest shares in the pharmaceutical sale in the coming years. That is some trend in the retail sectors. Right now we have 57,000 pharmacies in Vietnam, which is the traditional, mama shop, papa shop to sell drugs. And equivalent to 6.6 pharmacy for 10,000 people. And and in Vietnam right now we have a race for market share in the pharmaceutical retail industries. With every big distributors jump into the pharmaceutical retail markets. And right now they are a race, and this is $1 billion market, so we have every big distributors coming into this market. Even like FPT is the technology distributors. Right now they jump also into the pharmaceutical market in the retail segment of the market. So at these, the retail is at the distributions and at the retail industry, in the retail segment of the distributions of the pharmaceutical products is very competitive right now. And we have about 5 to 6 very big players, but there are still 50,000 of the pharmacies, of the small papa shop, mama shop pharmacies in Vietnam. So the market is very competitive. One of the special things in the Vietnam regulatory framework in the pharmaceutical markets is that when we enter to the WTO, we make a commitment, and with that commitment, we prohibit FDI company to distribute drugs in Vietnam. So if you want to distribute drug in Vietnam, you need to be 100% owned by Vietnamese investors. So with that, I think that the Vietnamese government have leverage to deal with international, multinational drug companies, that if you want to distribute drugs in Vietnam, you have to cooperate with the Vietnam government and with the local, with the Vietnam distributors, with the Vietnam companies, and with the price that accessible for the Vietnamese market. So right now, at this time, we don't have much of the competition issues in the pharmaceutical market. Thank you very much.
All right, thank you, Mr. Nguyen Dak Min. The next presentation is I'm going to give you to Dr. Chandra Saitewan, the Commissioner of Indonesian Competition Commission. He's going to give us a brief on the Indonesia policy. Also, in the first section in the morning, we heard that Indonesia will change the law, right, and the effect of the competition. Hi, Dr. Saitewan, please.
Yeah. Okay. Thank you. Very good afternoon to distinguished speakers, moderator, participants. Thank you for the opportunity to represent Indonesia Competition Commissions and discuss anti-competitive practices and licensing in the pharmaceutical market. The pharmaceutical industry, The pharmaceutical industry in Indonesia is crucial for the well-being of the populations. The Indonesian pharmaceutical industry, the Indonesian pharmaceutical industry has experienced growth, yet in 2022, it faced a slowdown as the COVID-19 pandemic concluded. While its contribution to GDP increased, its performance growth was slower than previous year. The industry in Indonesia, the pharmaceutical industry in Indonesia, tends to require substantial capital and complex technology, primarily controlled by developed nations. Dependency on imported raw materials exceeds 90%, primarily sources from China and India. Despite rising demands for drugs, and domestic industry can only fulfill approximately 70 to 75% of the requirements, while the remainder relying on import. Next, please. Yeah, compulsory licensing of patent is intended to prevent inventions from being wasted due to non-optimal utilizations. It also aims to prevent patents from becoming an import control tool without contributing to economic or industrial developments. In Indonesia, the implementations of compulsory licensing of patents for pharmaceutical companies is regulated through the Minister of Law and Human Rights Regulation number 30 of 2019. Compulsory licensing of patent can contribute to domestic pharmaceutical companies because it involves a technology transfer process. This allows domestic pharmaceutical companies to implement, procure, and develop technology independently without depending on the technology of developed countries. However, achieving these results, an active rule for domestic companies to explore eligible patents and establish a sophisticated technology transfer system that is on par with the developed countries is important. One practice that negatively affects the next slide, please. Yes. One practice that negatively affects competition in the pharmaceutical sector is patent evergreening. Extended drug patents through minor modifications allows pharmaceutical companies to monopolize their products longer, limits public access to crucial drugs, and raises healthcare expense. Efforts to counter patent evergreening involve challenging patent validity through oppositions processes, emphasizing stringent patentability standards, and advocating for regulation allowing civil society participations in patents examinations. One infamous practice for patent certification in the pharmaceutical sectors is the pay for delay agreement. Yeah, pay for delay occurs when a patentee agrees to compensate a potential or alleged patent infringer to refrain from competing against the patentee for some period of time. Next, please. Yes. Under Indonesian competition law, intellectual property rights (IPR) in Indonesia are exempted from competition law per Article 50.B, encompassing agreements related to licenses, patents, trademarks, copyrights, industrial products design, integrated electronic circuits, trade secrets, and franchise agreements. Guidelines issued by the ICC clarify the condition of IPR exemptions, whether the license is required and whether it can be categorized as essential facilities. When no essential facilities are included, exemptions can be provided. Whether the IPR license agreement has met the requirement according to Indonesia's IPR law, and whether the IPR license agreement clauses contain anti-competitive attributes. The IPR license agreement is considered to contain exclusive agreements elements if it includes pooling, licensing, and cross-licensing, tying arrangement, limitations in raw materials, limitation in productions and sales, limitations in the sales and resale, and grant back. Next, please. Next, I would like to explain a case example handled by the ICC in the year 2010. Pfizer Indonesia and 4 Pfizer Group companies from the United States and Panama, along with Dexa Medica, have been found to engage in cartel behavior regarding alomadipine's-based anti-HIV hypertensive drugs. The evidence show identical pricing trends between Pfizer's Norvax and Dexa's Tensifast due to price fixing, supported by communications. In their defense, Pfizer and Dexa attempted to use the intellectual property rights exemptions. However, it was found that the patent right has expired. Yeah, ICC also emphasizes that according to the guidelines on the exemptions of IPR, such exemptions should not result in anti-competitive behavior, which significantly affects the competitions of the market. Due to this violence, the ICC imposed fines on Pfizer Indonesia in Indonesian rupiah 25 billions and Dexa Medica in Indonesian rupiah 20 billion. The way forward, the last slide, please. Yes. Moving forward, policy recommendations and advocacy efforts will be the best tools that the competition agency could utilize to help improve licensing regulations in the pharmaceutical sector. These policy recommendations and advocacy effort could promote competitions by utilizing TRIPS flexibilities in the patent law. Mandatory prescribing of generic drugs and allowing substitutions of drugs by pharmacists, as ICC's recommended in our case decisions in anti-hypertensive drugs, can be a way to increase competitions. Competitions agencies could also ensure a competitive national procurement of goods and services to reduce procurement prices in the pharmaceutical industry. Last but not least, to ensure the success of this effort, a close collaboration with the relevant sectors, regulators is crucial to the success of those efforts. This is all from me. Thank you very much for your attention.
Ma'am Macon, she will share her insight on pharmaceutical patent in Philippines, please.
Hello, I'll discuss about the patent aspect in terms of combating anti-competitive practices in relation to pharmaceutical markets. So as for discussion points, I'll first focus on the pharmaceutical filings in the Philippines, and then I'll go to the IP regulations and policies that's actually available in our IP code in relation to prevention of evergreening, as mentioned by our colleagues and blast presenters, and in relation to use of TRIPS flexibilities in order to promote access of medicines. So in first for the PH patent filings, as you can see, more of our filings for the last 9 years is focused more on from PCT or foreign filings. So our local filings is only makes up of 3% of our filings, so we're dependent on foreign filings. This also correlates to in relation to our procurement of source of active ingredients in relation to generic formulation. So our top filers for 2013 to 2020 is actually multi-companies such as Novartis, Janssen, Boehringer. Most of their products are concentrated on cardiovascular products, drugs, diabetes, anti-diabetic drugs, anti-cancer drugs, and also some for obesity or metabolic problems. So, in the onset of RA 9502, which is the Cheapest Medicine Act, this one is an act of the government in response to Doha Declaration. This promotes the cheaper medicines. This promotes and ensure access and affordability of quality drugs and medicines to all Filipinos. This law actually was the one responsible for bringing about the amendments in our patent law. So, accordingly, the Doha Declaration, Philippines is a signatory of TRIPS agreement. So, under TRIPS agreement, we are required to grant patents to products, and that includes pharmaceutical products. This also includes the granting of patent protection to not only to products, but it also extends to use and process in making those products. So under the Doha Declaration, the World Trade Organization recognized that patents may also promote monopoly in relation to pharmaceuticals. So they recognize that the member states can use TRIPS flexibilities provided under the TRIPS in order to promote access to their essential medicines. So among those is the compulsory licensing, and the member states are free to make their own grounds in granting compulsory licenses. This also provide the freedom to choose exhaustion regimes. So in the Philippines, we are actually, we promote national exhaustion. However, there's a very specific exemption in relation to drugs and medicines wherein we practice international exhaustion. So meaning the first sale of the originator drugs, if sold anywhere in the world, even not within the national jurisdiction of the Philippines, we can then buy that without or import that without the problem of infringement. So there's also 3 waivers under the TRIPS Article 31. This removes the limit on the exportation of generics products. Before, compulsory licensing only grants the supply. So those grant the supply of medicines that were manufactured in relation to compulsory licensing only to supply the domestic market. However, under the waiver of Article 31 TRIPS, there is a removal to the limit of the exportation of those products that were made during compulsory licenses in order to supply the countries which have no capacity to manufacture their own generics, and or those that may have a capacity to manufacture their own generics but insufficient to supply the demand in the market. So under TRIPS flexibilities, the Philippines actually have licensing agreements, which is voluntary licensing, compulsory licensing, and special compulsory licensing. There's also parallel importation and the use of BOLAR provisions. So what is BOLAR provisions? So BOLAR provisions provide exemptions to those generic companies to actually use the product, patented product. This is only for regulatory purposes. So even if the product is still covered under patents, the generic companies can now use it to provide testing, to provide their own testing and use it for their regulatory approval. So this ensures the faster entry of generics upon the expiration of the patents. So under voluntary licensing in the Philippines, we have revised our implementing rules and regulations. This became effective on February 21 of 2020. It includes the prohibitory and mandatory clauses, which should be, which is important to combat the anti-competition process during licensing. There's also the effects of conformity. In relation to conformity, actually, if your licensing agreement does not contain any of the prohibitory clauses and contain the mandatory clauses, the registration of such licensing agreement with the IPO field or the patent office is actually not mandated. However, on the instance that it was found that the licensing agreements actually violates the competition law and actually violates also the prohibitory clauses under the voluntary licensing agreement, then it will be unenforceable. There's also, of course, exemptions which the generic companies or the licensor and licensee may file to the IPO field in order to exempt them from the use of the prohibitory and mandatory clauses. One of the exemptions, if it includes high technology content, increase in foreign earnings, employment generation, regional dispersal of industries, and of course, the substitution of local raw materials. The IRR also includes the registration procedure. So I'll focus more on the prohibitory clauses. So the IRR and even the IP code contains 15 prohibitory clauses. This can be akin to prevent anti-competitive that is found mostly in voluntary licensing. One of the prohibitory clauses will be the tie-in purchase, wherein the licensor will be the one to tell the licensee where to source the raw materials. So that's prohibited. Also the price fixing, wherein the licensor will be the one to have the to fix the price of the manufactured product by the licensor. There's also other, which is the free grant back. The free grant back means that the licensee will be mandated to give the improvements or any improvements during the technology transfer to the licensor for free. So those acts are deemed as anti-competitive and those are prohibited. Those should not be found in your voluntary licensing agreement. Others, we also have a specific catch-all prohibited clause, which is which states that other anti-competitive clauses. This is just for blanket and blast protection in order that if the prohibited clauses provided under the law is not sufficient or does not cover any acts or clauses included in your voluntary licensing. So the Philippines practices voluntary licensing more under the Medicines Patent Pool, so MPP. This was actually created to have voluntary licensing for HIV, which later on extended to other drugs and medicines concerned to cardiovascular and other diseases. However, what was unique for Medicines Patent Pool voluntary licensing is that they publish their voluntary licensing agreements. This is not found in most of voluntary licensing practices in other jurisdictions. Even in the Philippines, there are we only demand registration, but we do not publish the voluntary licensing agreements for confidentiality purposes. So some of the key issues, this was based on a study on a voluntary licensing made by other jurisdictions, not only the Philippines. It was pointed out that there's lack of transparency, again, because voluntary licensing agreements is deemed as confidential, so we do not publish already concluded licensing agreements. We also have varying terms since voluntary licensing agreements depends on a bilateral parties of the licensor and the licensee, and it may be non-exclusive, so they can grant other licensing agreements to other parties. And those terms are not standard and may depend in relation to the other factors. So there's also the broad scope of the term patents. In entering voluntary agreements, patents is deemed as those that were granted and already granted by the IPO or the patent office. However, in some jurisdictions, patents were said to be those who are under opposition or those that were still not yet granted. So there's a broad scope in terms of patents, which may be the subject of voluntary licensing. There's also a differential treatment for different types of use of drugs in terms of dosage, age group, formulation. So one of the problems here is that the licensor may choose which type of dosage will they grant or which type of formulations will they grant to a specific country and not grant the same to the other countries. So there's also a geographical limitation, since voluntary licensing agreement gives the terms and agreements to the licensor and licensee, the licensor might exclude other countries from either the exportation or the importation of the medicines and drugs which were under the license. So there's also restriction on source of the active pharmaceutical ingredients, research and clinical studies. So this was actually one of the problems observed in different jurisdictions. But as we see in our IRR, this is resolved under our prohibitory clauses. So there's also the anti-diversion requirement, wherein those that were excluded under voluntary licensing, those territories, will not also be supplied by those who were licensed. So we also have a parallel importation. This was, again, in relation to the international exhaustion regime. So under the Philippines, we practice international exhaustion regime only for drugs and medicines. Other patent products, which is not drugs and medicines, we practice in the national exhaustion regime. So the right to import drugs and medicines may be available either to any government agencies or those private third parties. However, in the Philippines, since 90 to 95% of the essential medicines declared under WHO has their patent near lapse or has expired, then parallel importation of those is not availed. Is no more availed of by the Philippine Pharma Procurement Incorporation. So they more rely on the generic counterparts. So since it's cheaper, but parallel importation again is a reserve instrument in case of market failure. So this compulsory licensing, it is also found in our law. So under compulsory licensing, we have the grounds of national emergency, extreme urgency, or public interest. That includes public health. The compulsory licensing is centered more on granting granting license to those who can manufacture or have the capability to manufacture. However, we also have the special compulsory licensing. This is in relation to special compulsory licensing to import. So this is to importation of patented drugs and medicine, but only for domestic consumption. Another is a special compulsory licensing to export. So this is a double special compulsory licensing in order to supply manufacture generic drugs to other countries that does not have capacity to make their own generics or insufficient. So as of to date, it's not yet availed of ever since the amendment of our law. There is one attempt case, but it was converted either to voluntary licensing. So there's that. So the special compulsory licensing should be upon the recommendation of the DOH. We also have a joint administrative order for that for the process of compulsory licensing and special compulsory licensing. This was released last 2021. So again, compulsory licensing is not that availed of from 2003 to 2016. I am not sure on the onset of COVID if it has been adopted more in other jurisdictions. In some studies, it does results to price reduction. And compulsory licensing may be availed of in terms of when the voluntary licensing agreement did not push through due to patent holders' refusal to grant license to third parties, or if you think that the terms of agreement would be prejudicial to your country. So compulsory licensing is always available. There's also non-assert declaration. So this was made by the company upon the issuance of compulsory licensing from another jurisdiction. So they made a non-assert declaration for their product after the issuance of compulsory licensing. So this one we've heard before, patent evergreening. So the Philippines, we amended our IP law. This is akin to the India patent law part, wherein we amended our patentability definition in order to account that new forms such as those there's an originator compound and you just discovered a new salt, new esters, new formulations of that drug, which resulted to a minimal innovation. So we made that as deemed as inherent and deemed as mere discovery and thus not patentable in our countries. Of course, there's a guidelines on that, on how we examine those cases that fall under new forms, new uses, and even new process. So as of yet, there's also no study conducted on the direct impact of the amendment on our IP law in relation to the to the price reduction of medicines. So under the onset of our amendment in our IP law, there is actually 382 applications from 2009 to 2021 that was deemed as under new form or new use or known process. 36% is granted. However, for those refused or under appeals or forfeited, we have 4.71% and 32%. There's spending of 26% as of 2021, so that's not yet updated. So thank you.
Right. Right. Thank you, Ms. Fatima, for giving us the overview and make us understand what is the IP in Philippines. I learned a lot of vocabulary today. That's new to me. So next is a Q&A question. Can I see the question? Oh, right. Which one would you prefer? One question? Can Philippines. Okay.
Okay, I'll answer one. Hold the harmless clause means that the licensor will not be liable in relation to any breach of contract in the licensing agreement. So we deemed this as anti-competitive because the licensee actually uses your products. So in relation to that, and it also stems, the use of that also stems from the transfer of know-hows. So in some point, the licensor also has the duty to actually give the proper transfer of technology to the licensor, to the licensee. So to hold them not liable in any terms of liability that will result to the voluntary licensing would be deemed as anti-competitive.
Thank you for that, attorney.
Can I have a question for Mr. Marcus? In general, what aspect of antitrust and IP licensing regulation can be strengthened to ensure the entry of cheaper generic alternative and innovation? That is for our Asian country, we can work together.
Yeah, thank you for that question. I think it goes back to one of the slides I had where I talked about the three systems. You can avoid a lot of competition problems if you start with a strong, good patent system. If you have a patent system that makes sure that patents really are new, novel, non-obvious, and useful, that's a good thing. If you have weak patents being issued that are being used improperly, that's a bad thing. A second thing is the regulatory system. Obviously, we need to make sure drugs are safe and effective. When you do that, you have to have a lot of regulations. When you have a lot of regulations in antitrust terms, that creates barriers to entry. It means somebody can't just from one day to the next enter the market. They have to go through the same processes in front of the regulator. But you can design the regulations in the first instance to take competition concerns into account. And then the third piece is simply working, like a lot of the discussion so far in this program, is working cooperatively with others across ASEAN countries, but also within your own government, working carefully with your patent and trademark office, working carefully with your sector regulators like the Food and Drug Administration. I think a lot of competition problems can be put to an end before they even become a competition problem if you work well with your other fellow government agencies.
All right, thank you.
So that's a patent system, a regulatory system, and let's collaborate with each other's government systems as well.
Yeah, I think that's a fair summary.
It's okay. So any question? I think it's enough for us, right, for the session. Thank you, everybody. Thank you, the panelists.
And with that, a round of applause for our Session 2 panelists and moderator, Deputy Secretary General Vardana Buti, Commissioner Setiawan, Deputy Chairman Min, Attorney Mayor, and Attorney Mamangon. Thank you so much. The fact that so many questions are coming in is very, very heartwarming. But again, do not feel like you're limited to just being on stage to have your discussions and conversations. We're actually over time, but I think everybody deserves a health break. Not necessarily a coffee break, but a 5-minute health break. Should you want to relieve yourselves, please step out. We will resume in 5 minutes for the last session. Thanks, everybody. Take this opportunity to stand up, stretch, get your blood circulation going. It is the final session of day 1. We'll be back in 5 minutes.
Smile so bright with eyes like these diamonds. Caution, I know I should have known. Right now you're not alone. I don't wanna get in trouble. See where you stand. I don't wanna see you crumble. To recall what we meant, all the words you never said, all the questions in my head. 'Cause you're trouble, yeah. Yeah, you're trouble. Yeah, you're trouble. 'Cause you're trouble. Yeah, you're trouble. Running. Everyone says that I should get going, start running. But how am I supposed to run when I'm falling? I don't wanna get in trouble. See where you stand. I don't wanna see you crumble. To recall what we meant, all the words you never said, all the questions in my head. 'Cause you're trouble, yeah. Yeah, you're trouble. Yeah, you're trouble. 'Cause you're trouble. Yeah, you're trouble. Yeah, you're trouble, trouble, trouble. Yeah, you're trouble. 'Cause you're trouble, trouble, trouble. Yeah, you're trouble. I don't wanna get in trouble. To see where you stand, I don't wanna see you crumble. To recall what we meant, all the words you never said, all the questions in my head. 'Cause you're trouble, yeah. Yeah, you're trouble. Yeah, you're trouble. 'Cause you're trouble. Yeah, you're trouble. Yeah, you're trouble, trouble,
Hi, Chris.
Hi.
Just to say, I can see you and hear you fine.
Hi, Alex. Can you hear me?
Ladies and gentlemen, please settle down. The program will resume. We'd like to invite everyone to please settle down. We will be resuming the program shortly. Thank you. Once again, good afternoon, ladies and gentlemen. I hope you all took the chance to stand up, shake it off. As we are in our last session for the day, allow me to give you the overview. The title of the last and final session is AI and IP in digital platforms. Is this a future competition issue? We're about to find out. Artificial intelligence has undoubtedly revolutionized the global economy. It increases output potential of various sectors. At present, multiple developers have been racing to be the market leader in powered platforms by AI. Although IP rights currently seem to not pose an issue with the accessibility of AI technologies, the winner-takes-all dynamic in digital platforms may make it an issue in the very near future. So ladies and gentlemen, this third and last session tackles the latest developments in AI and its growing role in the global economy, the complex relationship between AI and IP, and AI's potential impacts on market competition. The moderator, we have Commissioner Mara Victoria Querol of the Philippine Competition Commission, who I'd like to invite on stage with our panelists, Dr. Paul Chang, Senior Economist at the World Bank Group, and Mr. Iskandar Ismail of the Malaysia Competition Commission. Virtually, we have on screen, may I ask you to step forward for a group photo first? Virtually, we have on screen Professor and Chair of Data Science at the Asian Institute of Management, Dr. Christopher Monterola, and the Assistant Director of the Mergers Unit at the UK Competition and Markets Authority, Mr. Alex White. Dr. Monterola, may I ask you to smile? You're seen. You're part of the photo op. Is Mr. Alex White here as well? Shall we ask him to smile too and join us for the photo? Keep smiling. Look straight at the camera. One more? Oh, we're waiting for Mr. Alex White. So sorry. Thank you for your patience. So we have a group shot of the whole panel. You look great, Dr. Monterola. There he is. Hi, Alex. Alex White, please smile. There you go, side by side with Dr. Monterola. To my panelists here in the ballroom, everyone smile. Believe it or not, Mr. Alex White and Dr. Monterola, you look great. You are actually part of the group photo. Keep smiling. And we got it. I will now turn you over to our moderator, Commissioner Querol. Good afternoon.
Hello, good afternoon everyone. Welcome to Plenary Session 3, AI and IP in Digital Platforms, a future competition issue, ? It is my goal as moderator of Session 3 to trigger a discussion on the future of AI development, usage in the context of competition law and IP, to identify possible source of concerns in the use and control of AI technology in digital platforms, and perhaps discover some areas for future collaboration for antitrust, IP, and other regulators in relation to AI software and digital platform markets. This session seeks to tackle the latest development in AI and its growing role in the global economy, the complex relationship between AI and IP rights, and AI's potential impacts on market competition. Our panelists for Plenary Session 3 are 4 distinguished gentlemen. We have Mr. Paul Pompeu Chang of the World Bank. Next, we have Mr. Alex White of UK CMA, Dr. Christopher Monterola of the Asian Institute of Management, and my CC's very own Iskandar Ismail. Now, I would like to start the conversation this afternoon by asking Mr. Paul Chang a simple question. Should intellectual property rights adjust to AI products while maintaining competition protection? Mr. Paul Chang.
Okay, yes, so I thank you very much for this invitation to Dr. Michael Aguinaldo and also to the PCC for hosting this event. I think there should be a relationship, a close relationship between AI technology advances and also the intellectual property rights. I think we have seen in the previous session there has to be a lot of collaborations, but also there has to be a lot of innovations that can go through. And with these technological advances, what is going to happen in the case of competition, there will be a new restructuring of markets. That is something that is unavoidable, but also is something that has to be seen by the competition agency. In different ways, there can be a lot of abuse of dominance. There can be also mergers and acquisitions issues. So there has to be a close relationship between them. So more than adjusting one to the other is actually keeping an eye on them, because the competition issue has on its own roots innovation. So we cannot forget about innovation, and we cannot prevent that the innovation actually make some changes in the market by itself. But innovation is part of what comes with the technology, but also what comes with human behavior, with the strategy of firms. And it is in this interaction between the two that can be some kind of abuses, sometimes unintended consequences of what competition is. Yeah, over. Yes. Okay, very good. So let me do a short presentation on some slides on AI. So let me present to you some relationships between artificial intelligence and intellectual property rights. So for that end, I have put on this slide four relationships to keep in mind. The first one that you see over here, you see this nice painting here, and it was created by Paint Creative AI, and it's asking for a copyright. So the question is, can actually a machine that creates this nice picture, using some sketches over there, can be copyrighted? Because usually we think that copyrights can be done by people, right? But can a machine actually be a creator of something, right? So we have to ask, is it an artist actually who creates this thing? Is it doing unconscious? Because one part of being an artist is actually to create something consciously, right? Okay. Shall I wait? Okay, so let me do it by heart. So you have to be conscious about what you do, right? So we are asking ourselves whether actually, yes, okay, whether you have intentions or not. So we are not going to answer questions actually where our paintings or others, that the market is going to be disrupted completely. Can we go back, please? So it will be disrupted completely. Why? Because AI will have two things, a scale and a scope. So that means that you can produce a huge amount of diversity, this in a few seconds probably, or a few minutes, right? It will be a lot of scale because it can produce a diversity of them, and a scope, which a lot of variety, right? So what will happen with some of the artists that will take a lot of time to create this painting, right? They will be out of the market very quickly, unless they actually become much better than the machines. So that will be a good question to ask. So will AI break the market equilibrium? Does it really create a new market? And then we go to the number 3 over there, the machine-created art. So if you might remember or not, but this is actually that there is something that is created, like the painting I showed you before. But then we will ask, does it use any copyrighted material? Yes, no. Is it legally the way it is used? It is fair the way it is implemented. Can somebody complain about it? So if you can go through this simple decision tree, you are actually following what is a game. And what is a game? A game is something that is consisted, at least for the economists, on 4 things: the rules, the games, the strategies, and the payoff. So when we see this very simple decision tree, you can see that many decisions are taken over here, but also many rules. So it will be very easy to say, okay, so if we go through the yes, 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 then at the end I can decide that maybe I can finish this copyrighted thing, and maybe the machine can have the copyrights. Is that a different market from the other copyrights? That's a good question for us to answer. Because even if the consumer knows that this is produced by a machine, can it distinguish the two? Right? Because a lot of the things that goes in the market is also, can I make a difference between the two? And in competition, this is critical, as you very well know, because when you are going to define a relevant market, you need to know what are the substitutes in this market. So maybe technically it is different, but maybe for the consumer it's the same. That will create a huge problem, of course. But then, even if we try to sort it out, and with this, what we are saying is that there could be a market, right? If there is a market, then you know what's happening, especially in this forum. There will be anti-competitive behavior. And that goes beyond the painting, right? Whatever it goes, even if this relationship between AI and the intellectual property rights, the next question will be, okay, what's the problem over here? And the main problem over here is going to be the anti-competitive behavior that can happen in this market. Because people are going to do the same thing as what happens in informal markets. And here it's going to be different because in an informal market, you know what happens, right? You have products that are probably illegal, that they should not be there, and you compromise a little bit the quality by something that goes cheap. But with AI, is that going to happen? It's actually not. It's going to be, with technology becoming better and better and better and cheaper and cheaper and cheaper. So it's going to be very hard to fight against this market. So one of the proposals will be, let's open this market. Let's regulate this market. Let's actually take it by heart because this market is going nowhere. So, but can there be potentials for abuse? Of course there can be. Different ways that they can happen. Let us go to the next one, please. But one of the things that we have been talking about this AI is actually that the market, we can have to look at it because there will be competition in the market. But one thing that we should not forget, and especially here, is that these are public goods. Because we are always thinking on AI, and very similar to the previous session, on something that, yes, on private uses and this and the other. But we should not forget that the market also works because there are public goods. And the question over here is, are these markets actually breaking the relationship between private and public? And the public goods is something that is extremely important to consider. Because at the end, what do we want? Yes, we don't want the profits, the companies to abuse. But what we want at the end of all these market issues is to have well-functioning markets. Markets that create wealth, that gives prosperity to people. This is the end. Of course, we're going to have firms, we're going to have people. Yes, we are going to have rules. It is a game. We're going to be in there. But we need to have public goods. And that means that the decision of the public goods cannot be taken, and this is a position, cannot be taken by a machine. That has to be taken by you. But people like us, well, I believe that the AI is not going to take my job away, right? So we are still going to decide on what to do. And to tell the story, maybe it's a little bit heavy to read, but to tell the story, I was thinking about this movie that I saw a long time ago. And one of the issues that happens, for example, in the movie, I would say in the movie because I have not really known if this is real, but in the movie what happens is that the machine actually at the end uncovered the code. So the people from Europe or UK, they learned what was the next move that the Germans were going to attack. But was that the end of the story? No, not really, because the story continues in that they decided, even with the information, pretend not to know, so that the Germans will not really understand or do not have a clue that they know that they know the code. So it was a very strategic decision. So even with all this information that you have, somebody has to take a different decision at the end. Having the code is no guarantee that you're going to go ahead. So this is the decision that goes into what we're calling the public goods, the welfare of the people, the strategy. So you have to have trade-offs. So sometimes you're going to sacrifice a little bit for the better well-being of the markets and the society. So, but who takes that decision? It's not going to be a machine. It's going to be people like us, people who make rules, people who make decisions, who decides on things. And then, of course, that's what we're saying. So the human decision maker is going to be there, no matter what. It can get more sophisticated. Yes, it can. But we have to move beyond the private interest. We have to move beyond the private interest. We have to continue with the public good because this is what the rules are, right? And then, of course, it will come the issues of knowledge, of sharing knowledge, access to the data, access to many things that we already know through regulation and competition. But there can also be problems with abuse. Different kinds of abuse, exclusion, refusals, this is going to happen in different ways. Anyway, so let's go to the next one. Next slide. So this is mind-blowing, right? Nobody understands this. I say, okay, I'm leaving now. But if you look at this, actually, this was created by us in the World Bank. It's not a piece of art, but I wanted to put the main issues that we put on the other hand over here. This is actually a network, but it's an algorithmic network. And one of the speakers, I think it's going to be online. He's a professor, he works on network. Maybe he can explain better. But what this shows is actually the different relationships, the different industries. This is for a particular country. This data is real. So we created this graph showing the relationship between the different industries, how close they are, whether they have a comparative advantage for producing, what is the size of the business. And then there are actually different maps over here. So I'm not going to go in detail because that's not the purpose of here. But we are also measuring, for example, the ownership part. Are they dominated by SOEs? Are they dominated by private firms? And what is the legal framework behind it? So this is what we said over here. This is a complex interaction. This graphic is actually a complex interaction between technology, law, and market dynamics. And this is actually the bread and butter and law economics. This is what competition agencies do. But this was created, this network was created with algorithms. But this is not AI. It is not AI. It was created with network. It resembles what an AI can do. But now what AI will do in the future, or very soon, is that it will take other data and will make a different map over here. It will update how this changes, how these little bubbles move in this space, and what becomes dominant or not dominant and this relationship. This is what an AI will do. Very much similar with what doing a painting. So I take the painting and I start moving, changing the colors like this. Well, imagine this in a more technical way, in an economics setting, and how these ones will change. So this is what AI will do. Will that leave me out of my job? I don't know. Well, I hope not, right? I might retire before that. But, so the issue is over here. Even if I have an AI who can update these ones, what are going to be the policy-making decisions over here? The machine will not do. The machine will give you a lot of scenarios, possibilities. You can ask the machine to do. You can interact in a different way, but somebody has to take a decision. Somebody has to take a decision that maybe in this country we want an SOE, or maybe we don't want an SOE, or maybe we want PPPs, right? A combination between public and private. Maybe what we want is not to develop certain areas of these industries, and then you will see over here that some part of the graphics are a little bit white. This is because they don't have an industry. Maybe you will decide that the industries in which you do not have a comparative advantage today, you want to have it tomorrow. That one the machine will not do. It can give you the possibilities, but then you will have to decide. So at the end, there will be also a lot of behavior, because even if I know, if I implement central policies, competition policies, regulatory policies, something is going to happen in the market. Maybe it will be that a dominant player will become an oligopoly, right? Or a monopoly at the end, and then this picture that I see over here will change. So there are rules of the game. This is what we call this the imitation and judging game. Somebody has to imitate, but also somebody has to judge. I do the interpretation of what's going on with whatever we see. So to end the presentation, in this imitation and judging game, I try to make it simple for you. So what are the 4 things that we need to keep in mind? That there are going to be new markets. There's no question about it. There are going to be new markets. But with new markets comes new games. Games in which will be the new rules, new strategies, new players, and new payoff. Somebody will lose, somebody will gain. This is not a zero-sum game. So we have to be very much aware of that. But then with the game comes the behavior. So there will be new anti-competitive behavior, new strategies, new policies that will come in. But then at the end, you can see there has to be an allocation of rights. We have to take care of the abuses and collusions and vested interests as it happens in any market. And let's not forget, there is the public side of this one, the public goods. Not everything is private. We need to take care of the welfare, right? So there are many different ways of looking at this. Now, I'm not going to go in there unless you ask me questions on that. But then the last part is the market destruction. This term was, for some of you who knows, the market destruction was created by Schumpeter in the 1950s. Schumpeter actually decided, or make a point, that the markets are in constant evolution. And there is a creation of markets and destruction of markets. I think that under this term, actually, and the new economic growth theory that uses all these things, the creation and destruction of market is going to happen even faster. With this technology, you think it's going to happen faster. It's not going to go away. It's going to happen faster. So we better be ready for the creative destruction of markets. So all this is going to be a big cycle of creating new markets, creating new rules, but then again, creating new markets, creating new rules. Because AI technology, it will depend on the creation and welfare that we create from these new markets, depend on our rules, and depends on our interpretation or uses of the rule. So we cannot be oblivious in a competition agency, for example, that we say, no, well, everything is competitive. Yeah, it's competitive, but that doesn't mean that the behavior there is not anti-competitive behavior in there. So it depends how we use the rules, how also this market will evolve. And this is the part of the creative destruction of markets. So I hope you will see the movie at some point if something triggers on you. And if you want to buy the nice picture that I showed you at the beginning, just ask me at the end, I will sell it to you. Thank you.
Thank you, Paul, for that presentation. But I will ask Paul a question, a first crack. You will have the first crack in this question, and perhaps something that the other members of the panel could also answer. Would you think with the advent of self-learning AIs, will this be encouraging or impeding competition? Maybe this is something that could be answered later when everyone has already gone through their respective presentations. Do we have Alex online already? Hi, Alex. Are you there? Can you hear me?
Yes, I can, thank you. Can you hear me?
Yeah. Alex, you're with the Mergers Division of the CMA. Can you give us or share with us some of your views as to the role can merger control play in overseeing investments made by big tech firms in AI developers?
Yes, certainly. So digital technologies have really transformed how we live and work over the last few decades in various ways, and it's brought lots of positives. And AI, you can really see as the latest tech wave with the potential to really turbocharge the changes which we've already seen. And for that to be bringing the most benefit for people and businesses, it's really important that competition in relation to AI remains strong. And the clearest lessons we've learned from past experience in relation to digital markets is that the most effective path to ensuring open markets and healthy competition is to prevent entrenched market power from developing in the first place. And merger control can play a really key role there, in particular overseeing acquisitions by large digital incumbents of, for example, AI developers, and where those transactions are motivated to weaken competition. So I think merger control is something which will be important in that space alongside other aspects of competition law.
Another question for Mr. Alex. Do merger control authorities need to be considering further any new theories of harm to tackle digital mergers?
Yes, well, this was something I was going to come on to in my presentation, but I think there has been, in recent years, a fair degree of debate about whether current theories of harm which competition authorities adopt when they review mergers, whether they're really up to scratch. And some of the issues I think competition authorities have faced, especially in the digital space, is you're dealing with new products which we're not familiar with, and there could also be inflations between different markets as well, and those interrelationships can also give rise to competition problems. And I think from the experience we've gained over recent years is that you can still apply the kind of traditional frameworks which we use when we assess mergers to those new situations. But it can just take some kind of more kind of taking greater perspective on how you apply those principles. But I think it might be clearer when I come to my presentation to cover that point.
Okay, please proceed with the presentation, Alex.
Thank you. So I was going to cover the approach we take to merger control enforcement in the UK. And I wasn't going to talk exclusively about our approach to mergers involving AI, not least because we haven't actually reviewed many mergers in that space to date, because it is so novel. But I was going to cover our approach in more general terms and how it's developed in recent years to review mergers in digital markets more broadly, which of course will have a read across to how we might assess mergers which might involve AI going forward. Digital markets have widely been recognised to have experienced under-enforcement by competition authorities in recent years, which has contributed to large tech firms entrenching their powerful positions and spurning competition authorities to rethink how they approach merger control in this area. So I was going to speak about the CMA's approach in relation to mergers in digital markets. Excuse me. And as often those mergers are global and raise similar issues across other jurisdictions, I hope that the approach which I'll be exemplifying will be of interest beyond the UK, including in Southeast Asia. And there's two main topics I wanted to cover in particular. Firstly, I was going to cover the approach we take to jurisdiction, and then secondly, about the substantive assessment that we apply. So firstly, on jurisdiction, I appreciate that many of you may not be familiar with UK merger control, but in a nutshell, we have a voluntary regime. So this means that it is not necessary for merging firms to notify their transactions to us. Either they can choose to notify voluntarily, but we also reserve the right to call in a merger for review where we think it's merited. And in either of those situations, the merger needs to meet our jurisdictional thresholds. And there's two main thresholds. Either the turnover of the target company has to exceed a certain turnover threshold in the UK, which is currently £70 million, or the merging companies have a combined share of supply of any good or service of 25% or more in the UK. And there's 3 points I wanted to. So, for example, rather than just basing the share of supply test on share of sales, which is the traditional approach we would take, there have been cases where we found jurisdiction based on the parties having a 25% share of UK active users on a particular digital platform. The second point I wanted to cover about jurisdiction is that in the UK, there's no requirement that a merger must involve UK companies or companies principally active in the UK. And this is helpful sometimes because you can get situations where you have a merger involving non-UK companies that have their centre of gravity elsewhere, but they still have a material impact on a UK market. And that's been the case in a number of recent digital mergers which we reviewed, including Meta Giphy and Microsoft Activision, and I'll come on to both of those cases in a bit more detail shortly. So the second main topic I wanted to cover, aside from jurisdiction, was our substantive assessment. We updated our merger assessment guidelines in 2021 to reflect how we should assess mergers in the digital space. And I think there's 5 key points I wanted to highlight from the changes we made. The first one is how we provided new guidance on how we assess losses of dynamic competition. So competition authorities have traditionally adopted a static, excuse me, a static assessment, looking at the merging firm's current positions on a market and whether the merger would result in excessive concentration. But in fast-moving technology markets, an important aspect of how firms compete also involves making efforts to innovate, and firms that make such efforts then incentivizes their rivals to also innovate and make efforts to innovate as well. So, in other words, competition is not just a static form, it's a dynamic process. And this then means, in a merger's context, that a merger between, say, a large incumbent firm and a smaller rival, or a rival which hasn't even entered that market properly yet, excuse me, could still be problematic. And a good example of that that we've investigated quite recently in 2021 was Meta's acquisition of Giphy. So Meta, of course, is the parent company of Facebook. And Giphy is a company that creates GIFs that you use in mobile messaging, like on WhatsApp. And one of the concerns we had with this transaction was how it could result in a loss of potential competition in the UK for display advertising. And this was because, on the one hand, Facebook is the largest provider of display advertising in the UK and one of the largest globally, through its social media and messaging platforms, Facebook, WhatsApp, and Instagram. And on the other hand, Giphy was a new entrant that has grown rapidly to become the largest supplier of GIFs globally. And initially, Giphy was supplying those GIFs to messaging services free of charge, but it was experimenting with a paid alignment advertising model where advertisers would be charged for more prominent placement of their GIFs in Giphy's trending feed. And at the time of the merger, Giphy had introduced this paid advertising model only in the US, but it was making efforts to expand that model elsewhere, including in the UK. And we found that this model of advertising, whilst different to Meta's, was likely to closely compete with Meta's more traditional display advertising. So we were concerned ultimately that Giphy's efforts to expand and develop its paid alignment advertising was imposing a dynamic constraint on Meta, and by acquiring Giphy, that constraint would be lost. The second point I wanted to cover was about the approach we take to the counterfactual. So the standard approach we take in many competition authorities is to adopt a counterfactual where you consider whether the merger would be reducing competition compared to what would happen absent the merger. So the normal approach is that you compare the merger to the position pre-merger, which in many ways is kind of like a backward-looking approach. But when you're looking at a loss of dynamic or future competition, you may want to take into account not just the position of the parties prior to the merger, but whether absent the merger, they might have grown and become a stronger competitor in the future. So again, to take the example of Meta Giphy, Giphy had, as I said, developed this paid alignment advertising model. It hadn't yet introduced it in the UK, but it was making efforts to expand. So for the purposes of the counterfactual that we adopted in that investigation, we considered that absent the merger, Giphy was likely to continue making efforts to expand and to innovate over the short and medium term, and to try to become a stronger rival to Meta than was currently the case. So that was an example of us adopting a future-looking counterfactual, which has been a relatively novel approach to the counterfactual assessment. The third point I wanted to cover about the substantive assessment is how we deal with uncertainty when examining mergers. So, as I've been mentioning, particularly involves an element of uncertainty, and this is reflected in the legal standard that we apply. So, in particular, if we have a merger which we're reviewing at a phase 2 level, then we have to consider whether it's more likely than not, i.e. more than 50% chance that the merger would give rise to a substantial loss of competition. But when you're looking at theories of harm based on a loss of dynamic or future competition in a fast-moving market, predicting what would happen in the future can involve a significant amount of uncertainty. So we've been clear in our revised guidance that the presence of some uncertainty will not in itself preclude the CMA from concluding that our substantive test is met. And to exemplify this again through the case of Meta Giphy, in that case we didn't have 100% certainty that Giphy would, absent the merger, introduce its paid alignment model in the UK, or that ultimately it would be successful in competing against Facebook. But the fact remained that Giphy was a threat, and the threat of it becoming successful was real and valuable in influencing other companies, including Meta, to innovate. And again, that was the case even if it wasn't clear what innovations that could be encouraging Meta or others to come up with. So we found that the removal of that threat was sufficient for us to still find that it was likely that the merger would reduce competition and that our substantive test was met. A fourth point I wanted to cover was about the evidence we rely on in such merger cases. So if you're trying to assess how competition might evolve in the future, you have to accept that the types of evidence you have available to you is more restricted than in a standard case. So traditionally, we would place quite significant weight on market share data, and you normally look at the years preceding the merger. But such data probably will not be a good indicator of how competition will be developing in the future. So what we've tended to do is rely more heavily on alternative sources of evidence, in particular the views of third parties, and something else which we've covered in some detail in the revised guidance is the weight we place on internal documents from merging parties. And we found that this can be really informative to help us understand how a firm sees its growth trajectory in the future and who they compete with. And sometimes the document collection exercise we've undertaken has been pretty significant. So, for example, in the in-depth review of Microsoft's acquisition of Activision, we received over 3 million internal documents from the parties, including key strategy documents and emails among senior staff. And the fifth and final point I wanted to cover was the approach we take to vertical and conglomerate mergers, i.e. mergers not between competitors, but companies active at different levels of the supply chain or in adjacent markets. And traditionally, such mergers were often viewed as benign. Rather than reducing competition, they can give rise to efficiencies and be pro-competitive. But the increasing occurrence in the digital context of mergers taking place in adjacent markets or with complementary products has highlighted the need to undertake a broader assessment of potential competitive harms in relation to these mergers. And so our revised guidance now recognises and gives new emphasis to the potential concerns that can arise, such as where a firm with market power in one market seeks to leverage that power to foreclose current or potential rivals in adjacent markets. That said, we still use the well-established ability, incentive and effects framework to assess theories of harm in this space. And this goes back to the initial question which you had asked, Mara, but I think often in these, with these digital mergers, there's been increasing concern about how ecosystems might be used and how they could be anti-competitive. And one of the issues there you have multiple markets, and it's not a traditional vertical case necessarily. However, we have dealt with cases where an ecosystem has been relevant, yet we have still applied our traditional theoretical framework. And one recent prominent example of this would be Microsoft Activision. So the concern in that case was how Microsoft could, post-merger, after acquiring Activision, use its control of Activision's gaming content to foreclose its rivals in the provision of cloud gaming services. We had found in this case that cloud gaming really has the potential to transform the gaming industry in the next few years by allowing consumers to play games without having to pay for an expensive console or needing a very high-powered PC. And Microsoft already had a very strong position in cloud gaming because it could draw on its multi-product ecosystem, covering PC operating systems, cloud computing, gaming consoles, and game publishing. And Activision, as you may know, is the creator of some of the most popular games in the world, including Call of Duty and Candy Crush. And its games were likely to be an important input for any cloud gaming provider in the future. And we found ultimately that if Microsoft were to acquire the whole of Activision, it would make Microsoft even stronger in cloud gaming and afford Microsoft the ability and incentive to make Activision's content exclusive to its own platform and in turn foreclose rivals. And I just wanted to highlight that in that case, we did apply a vertical foreclosure theory of harm, which is quite a kind of standard theory of harm. But when we considered market power, we took into account Microsoft's gaming ecosystem and its position in various markets. So I think that exemplifies how we've been able to deal with quite a novel factual position, but still using a standard framework. So I think those were the 5 points I wanted to cover about our substantive approach, particularly how it relates to dealing with digital markets, but I think it would be particularly relevant in the future if we have to deal with cases involving AI.
Thank you, Alex, for that extensive discussion on merger review in the context of AI. Do we have Dr. Monterola online?
Yes, Commissioner.
Yes, Dr. Monterola has played a pivotal role in crafting the AI roadmap of the Philippines. And a question that has been at the back of my mind for quite some time is, how are local businesses starting to adopt AI technologies? And what is the sentiment within the business community with respect to AI? Mr. Monterola, please.
Oh yes, right now, especially because of the large language models and generative AIs, there's this FOMO feeling, fear of missing out, if they will not become part of the AI community. And I will be giving a discussion on this context and the global context in general, Commissioner.
Okay, you may proceed with the presentation, Dr. Monterola.
Okay then. Yes, thank you. Thank you for that. So yeah, my presentation is about AI and the new age of competition and innovation. Next slide, please. And I will start by answering in affirmative the question of whether this will be a future area of competition. It has been an area for competition. It is now, and it will be bigger in the future. So my main thesis in my presentation is that the AI revolution is indeed reshaping industries and societies. And my role for today's presentation, my role in today's discussion is to stimulate and give you a perspective on this by showing you the actual power of AI in reshaping industries and societies. Next slide, please. So the technology with, this is one of my role as a technologist in a business school, is to look at the technology that actually impacts other technologies, impacts wealth creation, impacts the jobs of the people and the combination of which. So these are just some 4 organizations that I not typically cover: Gartner, MindMagic, SaaS Trends, etc. And the point that I would like to make here is, next slide please. 70% of the most dominant technology in this the different technologies that are covered here is basically because of the so-called artificial intelligence. Next slide, please. And if you look at the technology with the greatest impact for disruption, and looking at this from 2017 to 2018, I tally these numbers, and artificial intelligence indeed roughly accounts for about 70% of the technologies that drives innovation and disruption. Blockchain and cloud computing adds to the other 20%. Now, this so-called generative AI is another game changer, and according to the recent research by Goldman Sachs economics team, they could substitute up to 1/4 of the current work in the US and Europe. Next slide, please. Now, again, as mentioned by the first speaker, by Mr. Paul of World Bank, one of the things that we are seeing now is that innovation is not just happening, it is accelerating. And this has been predicted by Schumpeter in the 50s. New paradigms are being developed, new business models are being developed, and the so-called Industry 4.0 is a combination of the fact that we are producing a lot of data. Every 2 to 3 years, we increase the amount of data that we have by 9 to 10 times. We have bigger storage. In 1970s, 1 megabyte of data cost $1 million USD. Now this is around 10 to the -5 of a USD, and it's getting cheaper exponentially. And we have very powerful computers. The 5,000 operations per second in the 1970s will cost you $6 million US, not even including the inflation, to crunch that speed. The most recent iPhone 14, for example, can do a crunching of up to 1.5 trillion operations in 1 second. And it is something that can fit in your palm. Now, as a result of this, next slide, please. While human lifespan keeps on increasing, lifespans of company, on the other hand, as predicted, keeps on decreasing. In 1932, 1937, the S&P 500 companies, the 500 biggest companies in the world, can stay afloat for 75 years. But in recent years, this company can only stay afloat for 12 to 15 years. And one of the biggest reasons for this is this Industry 4.0, right now driven by the so-called artificial intelligence. Next slide, please. And in 2017, when they surveyed 3,000 C-level executives and asked them what is that specific technology that can change or that can innovate their product or can disrupt their operations, about 76% of them mentioned artificial intelligence and that they are investing in AI. By 2018, this is 93%, and virtually everyone now is investing on this so-called AI. And it becomes both a competitive edge, and this is also a technology that if you need to be relevant, you need to be part of this game. Next slide, please. So again, if you look at the richest people in the world, these are all in the STEM fields, you can see, except maybe for Warren. And you'll see that the reason why they are among the richest now is that they were able to maximize the utilization of data and artificial intelligence in the current times. Now, Elon Musk all the way to Sergey Brin, who owns Google. Next slide, please. And the most innovative companies in the world, the so-called Gandalf, Google, Amazon, Netflix, DBS, Apple, LinkedIn, Facebook, the same story. No? Ability to understand data and at the same time an entrepreneurship spirit. So Page and Brin invented the PageRank algorithm, and that is in no time they were able to beat Yahoo as a search engine, and so on and so forth. Next slide, please. And government now around the world see AI as a nation-defining capability. The way they see the strength of the army or the presence of oil as the nation-defining capability in the previous decades. And to make to show you intimately what this can do to companies, allow me to share some of the works that we have done. Next slide, please. So we have completed more than 72 data science projects to date. And you can see that we've been working with government, multinational companies, SMEs, large enterprise here and abroad, academia, media, NGO, international organization. And for those who are profit-seeking, we were able to give a potential revenue to our partners of up to $102 million in the last 4 years. And next slide, please. So it is non-specific, and also it's also domain agnostic. So the guys that we've worked with from sales, military, manufacturing, FMCG, energy, good portion of which is in education sector. This happened especially during the pandemic, where we work with DepEd and CHED, e-commerce, agriculture. Again, next slide, please. One of the things that I would like to highlight is that you can find data science in almost every field, any field. No? Just to give you an example, this is a manufacturing company, one of the top Forbes top 500 companies that we've worked with. They have a product that has a market share of more than 90% globally. And one of the problems that they ask us is if we can perform predictive maintenance on their machine, and also to understand human-machine interaction so that there will be less delays in their productions and shutdowns. So they have machines that can cost as much as $500,000, and if there's no one operating that, or if the machine has a problem, then it costs a significant amount in their productivity. So as you all know, manufacturing industries, it's a cutthroat industries. If we cannot be competitive on R&D, then it will become, it will be easy for them to actually move to more efficient locations, for example, China and Vietnam. So let me show you the results for this particular component. Go ahead, please. So yes, for just one product, we can save them $153,000, okay, for 1 month, and they have hundreds of products. So this is true. Now, this is what AI can do. And these are the numbers given to us by our stakeholders, normally their CFOs. Next slide, please. So this is a work that we've done with the Bangko Sentral ng Pilipinas. As you all know, BSP is responsible for monitoring more than 500 institutions every month. Next slide, please. And every single one of these institutions, every account, there are about 2,000 items, 40 person hours per account, and the total amount of time that they are spending just to plug potential pattern breaking or anomalous behavior is about 500 times 40, which is about 20,000 man hours. Next slide, please. By combining, next slide, artificial intelligence in network science, the one that was presented by Paul of World Bank a while ago, it's possible for us to reduce this 20,000 person hours per month to just 11 minutes. This is a real thing that an AI will be able to do. Next slide, please. Or even works on things like this one. This is an interesting organization. They have a 1 billion amount of money that they can loan, and they don't choose who are the individuals who will be asking for their loans. They are a Christian organization, and their goal is anyone who needs them, they want to give them money. But of course, the goal is hopefully that they will be able to get their money back eventually. And therefore, even without credit history, they ask us, can AI help us in forecasting who most likely will default? Next slide, please. And so they asked us to determine, I masked some of the components here, but it is actually possible from our end to determine who are the customers most likely to default based on the applications that they send and their behavior. Next slide, please. And because of this, we were able to save them 56 million savings, okay, in a year because of the AI model. So again, my point here and the reason for my presence here is to again tell you that this is real, no? That it will be AI and data will be part of the future competition. Next slide, please. Or this is another thing that we work with. We work with one of the biggest motorcycle loan financing company. And with AI technology, with deep learning technology, it's possible for us to immediately give you the cost of a refurbished bicycle by looking at the audio and taking a photo of the bicycle. Next slide, please. So again, data science and artificial intelligence applications is in almost everything. Art, etc. Next slide, please. I cannot overemphasize this. Now, one of the game changer is this so-called large language models, very well represented by the so-called chat GPT. Next slide, please. And as you know, ChatGPT took only 2 months to have 100 million users. In comparison, Facebook, Twitter, and even Pinterest, it took them 5 years to come up with 100 million users. TikTok, who is from a country with more than 1.4 billion potential users, took even 9 months to have this. ChatGPT is just 2 months. Next slide, please. And this is becoming very, very powerful. No? The compute time for ChatGPT 4 is now at, they been running this for 13 months now, and the total amount of money, just the compute time alone, is 320 million. And the GPT-4 now has roughly about 50 trillion parameters, though. So there's an update since I make this slide. That is nearly the same number of parameters of an actual human brain. And this is expected to improve significantly. Next slide, please. And that, yes, indeed, there will be a lot of invention, most likely that ChatGPT will be able to create and systems like such. In fact, right now, ChatGPT is more intelligent than your average lawyer, biologist, psychologist, and statistician. No? When they took the law bar exam in the US, it's at 90th percentile. An average lawyer is at the 50th percentile. This one is at 90th percentile. And recent results indicates that it's now at nearly 98th percentile. Next slide, please. So to conclude my presentation, again, artificial intelligence, generative AI tools like ChatGPT is drastically changing the landscape of finance, businesses, and society. And a good portion of the inventions, IP that is now being created is because of this technology. And the question is, are you ready? I really think that this is the second coming of the Renaissance period. Yeah, indeed, Schumpeter is right. Innovation is accelerating, but the acceleration right now is all reminiscent of the acceleration in technology that happened during the Renaissance period. That coincidentally is also the time when we have one of the worst pandemic, the bubonic plague, killing almost 1/3 of the population in Europe. Thank you very much.
Thank you, Dr. Monterola. Well, I will be asking someone that I know is more eloquent than ChatGPT. Okay, Mr. Iskandar, one of the questions that has been asked is, and I hope to be enlightened and wowed by your eloquence on this. What is AI to you? How does MYCC view it in the context of the ASEAN?
I think after listening to Mr. Dr. Monterola, I feel threatened. You know, because I'm a lawyer. Anyhow, you see, that's the thing. When he asks us, "Are you ready?" I'm very sure some of you do not have the answer, because we don't know what is an AI. To an IT engineer, it is something else. It's a human-based, it's a computerized system. You know, it can be something to do with robots. Yeah. When you go to a lawyer, he will interpret as something else. Yeah. So and then when it goes to academicians, they will say something else. So do we really know what is an AI? Especially to competition authority. If you do not have the definite definition of an AI, how are you going to take action against them? Against the creator of AI? How are you going to identify the competition issues? Yeah, that's the most important thing that we have to dwell into. You see, there's a leading researcher in University of California of Berkeley. He said people are getting confused about the meaning of AI in discussion of technology trends. That there is some kind of intelligent thought in computers that is responsible for the progress of which is competing with humans. We do not have that, but people are talking as if we do. So he somehow, telling us, while we are arguing what is the real or the right definition of AI, we are still grappling how to use AI even. You see, I'm very sure one or two of you have never used AI before. Today, do you know that Amazon just launched their AI chatbot? They call it Q. Yeah, it's only applicable for users or clients who use AWS cloud computing. Yeah, so there are many things that we actually do not know. So for competition agency, when we want to relate to IP issues, when we want to relate to cartel issues, when we want to relate to abuse of dominant issues, we're going to have a very big headache. Because when we talk about innovation, innovation moves faster than us. Dr. Monterello just now, they are gaining towards having the same level as our brain. Yeah, they even can be a better lawyers or statistician than us. To me, I just give names to them, to this AI. They can be our grammar guru. Yeah, they can be our idea factory. They can be our effective strategists. Yeah, knowledge validator. That is AI for us. But to find or to determine the right definition of AI is still an open question. I'm very sure when it goes, just imagine just now Mr. Mark, he was talking about pay for delay, right? They were investigating pay for delay cases. When it goes to court, the court changed the name totally. They call it reverse payment cases. So when it goes to court, it will become a different thing because the court will hear different sides. Yeah, at the same time, they say, okay, this expert will say A, this expert will say B, this practitioner will say C. So to me, this is AI. So are you going to use the AI definition by court or by the creator itself? So, but what I found is that in UK in 2018, the government of UK came with a very decent definition of AI. It says that technologies with the ability to perform tasks that would otherwise require human intelligence, such as visual perception, speech recognition, and language translation. But however, what they are saying is that the government recognizes that no single definition is going to be suitable for every scenario. That's the reality that we have to accept. Yeah? In US, in the Future of AI Act, it defines AI as any CMA UK. I think, it's a good paper. I think we should look at it because whatever it is somehow guide, especially the younger institutions such as the Competition Authority on how to understand AI better. Yeah. So I think we learn a lot from them, from the CMA UK research. Yeah, it's online. You can download it at any time. Yeah. I think I've answered your question. Yeah.
Yeah. Just an additional follow-up. Is my CC looking at any future collaborations to address this AI concerns?
Oh yes, of course. You see, we are still grappling with the issue of digital economy. We just wanted to start with studying the market of e-commerce, advertising, payment system, and whatnot. And then suddenly now we have AI. in the picture. Of course, I think the best way is to collaborate with the established regulators such as CMA UK, US DOJ, and European Commission, and maybe Japan and others, maybe Australia. Yeah, I think they can take the lead. We, as the the younger competition authority, I think what we should do is that looking at the suggestion by CMA UK paper on the AI foundation models, I think what we should do is that we have to talk to the stakeholders. In the sense that stakeholders, the creator of AI. Recently we had a discussion whether AI can create cartels. Yeah. But if we can prove whether AI can create cartels, who's going to be responsible? The AI or the creator? Or the benefactor? Is it? So, because the thing is, AI helps to get all the data, right? The prices of, let's say, of all the hypermarkets in Philippines. And then somehow they say, okay, the right price for everyone is 5 peso, let's say. So who's going to be responsible? You see, from what I know, there will be always human intervention in AI. Because, when it's man-made, it's not perfect. Yeah? So, we have to learn from the established regulators. We have to learn from the creator. We have to learn from the academician. I mean, we need to learn. We need to know more. So one of the small steps that we are taking now, we are going to conduct a roundtable discussion with our stakeholders, with the government bodies in Malaysia on 7 December. So we want to talk about AI, data. I think, Paul, yeah, AI and data, I mean, it connects, really close, right? I don't know, but the thing is, to me, AI is about data. Without data, yeah, it doesn't have a soul. Yeah, so that's how I see it. Thank you.
Yeah, I've been told to. Yeah, maybe we could have one question from the Slido. Okay. Which one do we want to address from the? Number two, okay. Among the originators of ChatGPT has lobbied among US legislators for its regulation. How do we adopt regulations to mitigate the adverse effects of AI? Anyone from the panel?
Well, I think I mean several answers to this one, but I think that there has to be a regulation. So markets work with regulations. This is an ideal topic that people think that markets, even if they are free markets, there are no regulations. There are regulations all over. And actually not regulating is also a decision to regulate. But so what we're saying is that whatever creation is there in the market, it needs to be regulated because somebody else is going to use it in one way or the other. And this is going to create distortions in the market. So unless you actually have a rule, a regulation that can tackle the different kinds of uses that people are going to do for the good and the bad, because this is the history of humanity, right? For the good and the bad. So I would say that it has to be regulated. Maybe there are different kinds of regulations that we don't want like a command and control regulation. We want incentive regulations. We want regulations that help to create markets. But we also want regulations, and I will take from this presentation, thank you very much to all the other speakers because I learned a lot from them, is that, and I try to put myself on something else too that comes into mind, which is at the bank, for example. We worry about the creation of wealth. It is clear that AI is going to create wealth. But at the same time, we also want to share prosperity. So what that really means? AI is also going to create a lot of gaps between us, right? So yes, we need to understand how it works, but also we need to understand how is it going to affect us, because some people will be under the curve, let's put it this way, and the difference between us is going to even be more. We were thinking about the digital divide, 20, 30 years ago, right? But today it's going to be even more obvious that this divide is going to multiply in many more times. So how is it that through our regulations, our actions, we actually make the markets work for everybody? This is what is important. So we can be mesmerized by what the technology is going to be producing, but also we should be mindful that we live in this one world. And then, therefore, we have to be careful of how this is used. So we have to think about regulations. And the other part, and then from that one I will end, is that it is also important that let's think about the sustainability of the resources that this is also going to imply. It is not just technology. We have all these issues with the climate change. So let's think about how AI, and I have seen several research on that one too, how actually AI can help, for example, to the circular economy, right? Which is much more than just recycling and waste management. It's much more than that. So let's take the positive on that so that we can actually help the different markets and the sustainability of the resources that are going to be used with all these new technologies and ideas, how to make this sustainable, because otherwise we are just polarizing the world between the rich and the poor, right? So anyway, I was also not threatened, but when I saw this from Chris, that all the time, richest people are not from my profession, right? So I am an economist. I said, what are you doing? So I was just thinking, well, not being threatened, I was just thinking, well, hopefully they have a good economist behind them. So, over.
Can I, while you say, we need regulation, I disagree a bit because, it's the human behavior. I mean, when we see something wrong, we want to, create these rules and regulation, for the market and whatnot. But, they're always 1 or 2 steps ahead of us. Yeah. So we have to ensure that our rules and regulation will keep up to the momentum of this new technology. So are we up to it? Do we have the capability to understand? And CMA have created their digital market unit, yeah, just to learn more, understand more, and maybe regulate the market. I can fully understand. But the thing is, in the end, to me, self-regulation is the first step. Yeah? And then maybe later, in the future, maybe. Okay, that's all.
I just, I cannot help myself. So I think, yes, but, lawyers are creating rules all the time. Every time that we sign a contract, every time I took a taxi, it is a contract. It's a rule, right? So, I mean, yes, of course, we live with regulations. We with implicit contracts. So they are all over us. So my idea is not to have a list of regulations in the sense that, okay, now let's do A, B, C like that. But we have to be mindful that we need rules. Otherwise, it is chaos, right? So that's why we were saying, we don't want a big informal economy that is going to be created out of this. And that's why I think we need rules, but in the positive way, right? So to create business, to create wealth, right? So we need to have new forms of interacting between us too, right? This is what is going to happen. But of course, sorry for the extension, and apologies to the other speakers. I wish you will be here so I can actually ask you more questions, but thank you.
But thank you very, very much. Can we give our panelists a round of applause? This is exactly what this is for. Discussions will be ongoing. It doesn't have to be limited to the stage. But for everyone who would like to participate, you can now do so, as I believe there's a quick break before your functions this evening. But let's give a round of applause for our moderator, Commissioner Quirol, Dr. Chang, Mr. Ismail, Dr. Monterola, and Mr. White online. Thank you very, very much for joining us. May I indulge my audience members to take out your mobile phones one last time and capture the QR code being flashed on the screen. This will be an evaluation form for how our day one proceedings went. Thank you very, very much. Please take the time to capture this QR code and fill out the evaluation form. Your feedback matters to us. Thank you very much again to our third and final panel for today. We have 2 more tomorrow, and I look forward to being back and learning more with you. For now, day 1 of the 10th ACC is concluded. Enjoy the rest of your day. Good afternoon, everybody.
Up 2 p.m. I don't know where we are. Looks like a cheap motel with our clothes on the floor. I don't know how we ended up here. And we've been flying high. Are we going too far? I got no cash left and I'm losing my job over you. But I don't care about that. But I got you close and kinda hoping that one day we'll get the rhythm of it. Yeah, 'cause no one knows if we're just jumping out the window, try to cling on to it. You got me holding on to something I know I can't burn me down. But I don't care about it, 'cause I got you close and kinda hoping that one day we'll get the rhythm of it. I've been chasing you like the tail of a dog. I don't get no sleep when we kiss in the dark like we do. I just love the way it feels. Yeah, I know it's bad, but I can't resist. When I look in your eyes, I don't know what is real. All I know is that I could go anywhere, anywhere, as long as you're with me. Oh, I'm drunk and I know it, but I got you close and kinda hoping that one day we'll get the rhythm of it. Yeah, 'cause no one knows if we're just jumping out the window, try to cling on to it. You got me holding on to something I know I can't burn me down. But I don't care about it, 'cause I got you close and kinda hoping that one day we'll get the rhythm of it. The rhythm of it. You got me holding on to something I know it can burn me down, but I don't care about it, 'cause I got you close and kinda hoping that one day we'll get the rhythm of it. Let's stick to the basics.